Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack's at Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculousness that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. Not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
I did it again. We're back. We're back. And we haven't missed a thing because they didn't come back yet. I think they said they were coming back at 1:20, but it is 1:36. I did a round trip to JFK and an airport pickup in that little break that we just had, and we're ready to go. We're ready to go. And so far, we haven't missed a thing. How's everyone today? Yes, please, prayers out to Duty Ron. For those who did not hear, he did it live last night, and he announced that he's been diagnosed with lymphoma, and he's going in for a PET scan today. He is the most generous YouTuber that I've ever met, one of the most generous people I've ever met. He's a mentor to me and a very dear friend. And so if you could please just keep him in your prayers, that would be so kind and generous of you, as always. Hi, Jules. Jules, are you in court today? Says we will have a verdict today. Judge K asked them if they wanted to stay late. They all said yes. I saw that this morning. He said he would keep them until 9 o'clock or later, even. All right. That's a hardworking judge, huh? Imagine if he was on the Karen Reed case, how fast that trial would have been. So fast. Trixie, thanks for coming to member. I'm just a girl in the world. Thank you for gifting 5 memberships. And to those of you who are lucky enough to be randomly selected by YouTube, welcome to our party. Sandy, JBAZ, Sue B, Tiddlywinks, and Tazzy, welcome. Welcome. So how are you all feeling? How are you all? Thank you, Sherry. A viewer made me that song. Her name is Melissa, aka Turd Ferguson. She wrote the lyrics and produced it, and I made the crappy video. So she doesn't get credit for the bad video, but I like it. I think it's cute. I love the song. I think the song is very catchy. It gets stuck in my head sometimes like an earworm. If you know, you know. Here we go. Christy's here for it. Abby and Rosie's mom is here for it. And I have to commend you all on being, for the 99% part of the time. This is the first trial that we have covered where there's been a real divide in the chat. And you guys have been very kind, listening to each other and listening to others' opinions and listening to people's personal experiences and listening to each other with grace and class. And I appreciate that very much. But, sometimes the trolls do come in. They hate me for various reasons, or for one reason, really. There's one case that they do not like what I have to say, and they're trying to shut me up. So I'll put the email up for you. Thank you, whoever asked. Because that Carly Gregg's family is coming on the show tomorrow with Bridget Todd. I don't know if I'm going to set the chat to members only or if I'm going to just turn the chat off, because I can't risk people getting in here and saying horrific things to the family, to Carly's family. I'm just not going to have it. So I'm going to put the email up. Thank you, Star Boy Glows, for asking for that. Here's the email. This is the only email that I use. Please use this one. If you have Googled and found some other email, it's not accurate. And so people say, why didn't you respond? And I'm like, what email did you send it to? So if you have any questions for Carly's grandparents, you can email them to me ahead of time. I understand that not everyone can afford to be a member, and I don't want to make it like that. And I understand that some people get gifted memberships that are not necessarily the kindest, nicest people. So if anyone has questions for Carly's grandparents, you may email them to me ahead of time. And if you'd like to stay anonymous, that's fine. If you want me to mention your name, let me know that too. And I think it's going to be tomorrow at 1 p.m. Eastern. So it is noon Central, which is, I believe, where they live, which is Mississippi time. So that's what we're going to do. I've been going back and forth about whether I should do it live, whether I should tape it and edit it. And so turn the chat off. Yeah, I don't, or I could tape it ahead of time and then do it as a premiere and we could chat in the premiere. I just don't think that I want to open the floodgates of the family being bombarded with really a lot of hatred, because there's a lot of hatred in that case. And remember, they lost a daughter, and a granddaughter, and they stood behind her for the entire trial, as did both families, both Heath's family and Carly's family. Yeah, thank you. I agree. So I just want to, say that ahead of time and let you guys have the opportunity to send questions to me that you would like answered, because I'm sure that you have a lot of questions for them. But I'm very protective of the family. I'm very protective of you guys in the chat, and I get a lot of heat for it. There's a lot of trolls out there. And listen, my mods are very experienced. They're very experienced. Many of them have modded for other channels and still do mod for other channels. And so they know who a lot of these trolls are. And then when they come in here and try and stir stuff up, they already know who they are. So when people are blocked and then they come into the comments with alt accounts and, accuse me of all this, that, and the other, it's just like, I'm creating a community here. And I think that I have the opportunity to do this. I have a voice. I'm going to use my platform for good. And I don't think that the hatred and the vitriol, it's not welcome here. And it's not, you have freedom of speech to go do that somewhere else if you like to. It's not going to hurt my feelings. You don't need to come in my chat and tell me why you'd rather go watch Emily D. Baker because she does this, that, and it's okay. She's got almost 1 million subscribers. It doesn't hurt my feelings. Go, please. It's beyond. You can't even imagine what I deal with on a daily basis. And it's just me. I don't have a whole team. Trixie, thanks for becoming a member. I'm just a girl in the world. Again, thank you again. Moon Goddess said, this is almost over. What a ride. Thank you. Thank you guys for watching. It's interesting. I think when we first started, at least for me, because we did a little bit of the pretrial, not a whole lot. And I was walking into this thing thinking this was going to be an easy one. This was going to be slam dunk, guilty. No, do not pass go. Do not collect $200. And it's been a ride, I think, for a lot of people. It's been eye-opening. I think there were a lot of things that we didn't know. I think that this community, more than a lot of other communities, have so many more life experiences than maybe other channels and other chats, because first of all, my demographic is something like 80% 45 and up. So we've been there, we've done it, we've seen it, we've lived it. And many of you are survivors. Many of you found me through, I don't know, the Maya case, where I was sympathetic to the plaintiff. Many of you found me through Ashley Benefield, where I was open to her experiences of perhaps being a victim and survivor of DV, who did everything she could to try and get away from him. And for that reason, maybe we have a lot of people who watch the channel, who are in the chat, who have lived this kind of stuff and been through it and survived child SA or DV, or lived in families where their parents were alcoholics, or have been in relationships with alcoholics or addicts. And I think that we have a very different perspective because of that. And I think it gives this channel maybe a little bit more empathy. I mean, I thank you. Thank you, Jojo, for your compliment. And I don't think that there's anything wrong with that. Clinton Nick says, it's just me. I'm interested in this and other trials outcomes, but I feel so emotionally invested in the Karen Reed trial. It's like a friend and a family member. Yeah, I think a lot of people feel that way because if you started following me from Karen Reed, when I first started covering it, I don't think that any other, I mean, maybe one or did any other law tubers start talking about it? I feel for a lot of reasons, maybe people didn't know about it, but maybe they just wanted to stay away from it because it was so divisive. Maybe because, a lot of people don't like Aiden Carney and they just wanted to, but like we got to fight for justice. We got to speak up about things that nobody wants to talk about. Because if we don't, nobody will. Maybe. Hi, Lori. Thanks for the 10 members only, or you can set it to subscribers of like 24 hours or a week. I don't think I can do that. I think the only options I have are like, I don't know, 5 minutes is the subscriber thing. I don't know. Let me just double check that. I just, I don't really feel like putting them in harm's way. And my other option is to just advise them, forget it. We're not going to do it. But I think people should hear from them. I think people should need to understand why they are standing behind Carly and why. Oh yeah, you can do a custom. I don't know, maybe. Why what they saw on that day was not Carly and why they believe or what they believe about why it happened. And there's so much we didn't get to hear about in that trial. Oh, another Long Islander. Thank you, Sue. Thanks, Sue, for the super sticker. Thank you. And going black, going black, going back. Barbara, thank you so much for the $10 super sticker. And thank you too. If you know, for becoming a YouTube member. I like your name. I say it all the time. If you know, you know. Then the stickers on the bottom of those rubber duckies. In Canton, IYKYK. And maybe that's why, I don't know, Clinton, let me know what you guys think, why people are so invested in Karen Reed, because she could be any one of us, right? She could be you, she could be me, she could be my brother, your sister, your daughter, your girlfriend, your wife. And if what's going on with Karen Reed could happen to any one of them, can happen to her, could happen to any one of us. And that's a scary thing. So here's my email. I do not respond to all emails. I do read them all. So just know that I have read it. I can't be your pen pal. I can't go pick up your kid in Florida and bring them to you in a foreign country and buy them a plane ticket, even if you promise me 5 acres of land. I kid you not. So there it is. Thank you so very much. The texts, are we back to this case now, Verbler? The texts in this case, in Sarah Boone, also speak volumes, yeah. Yeah, and I think the videos do. But I think nobody knows what really happened. In any relationship, in any case, I think alcohol is toxic. I think abuse, DV and alcohol combined is toxic. I think they were in a toxic relationship, Sarah Boone and George. I think they were, it was bound to end. I don't think it was bound to necessarily end well. This is a horrible, horrible, horrible outcome. But it seems like they are going to have some lesser included. So it looks like they're throwing in manslaughter and they're throwing in a negligent type of homicide. So we will see where this goes. I don't think she's going to get a not guilty. That's for sure. Sarah, be creative because we're tripping billies and kicking out bullies. I know. I'm protective of you all. Yeah, thanks, Sarah. What about that $70,000 loan? How much do you need, Scott? How much do you need? We'll grift a bit for super chats and we'll see if we can get you 70K. It's like 1 year's college tuition currently. Anybody have kids in college right now? How's that going for you? Guilty for manslaughter. This is Moon Goddess. I think she should have taken the deal. So do I. I agree. I think she should have taken the deal, especially since she knew that they had all those videos and all of that evidence. I guess she thought she could spin it her own way. I think this judge has done an excellent job of protecting the record for appeal. I think he's done an excellent job of making sure that she's happy with her attorneys and that she's happy with the job that they have done for her. So I do not see any possibility of an ineffective counsel appeal. And that's good. And this has been a very, very, very long road to justice for George's family. This has been almost 5 years that she's been in jail waiting, you know? So there's that. We also didn't get to see all the text. Yeah, he said something like there was like 150 pages of text, right? Mhm. Yes. Oh, yes. Oh, yes. John Jay says, by focusing on the spinning fan, it's like the Commonwealth didn't want you to notice where this mockery was taking place. Yeah, the weird thing about that courtroom, I will say, because I was there one day, is that it was very tiny. There was nothing else to focus on but that fan. So no, they had no seal like this. They had no painting that they could focus on. So I think that was probably like a whoever the pool photographer was, Court TV or Law and Crime's choice, because any other thing that they tried to focus on, they would get people in the shot, and so it just didn't work. But yeah, I mean, did you ever think you would miss the fan? Christina Reynolds, I just also want to add, and I'm not accusing Sarah of this at all, but a friend of mine, a male, was in a DV relationship and she faked her injuries by injuring herself. That's sick. That is sick. And there's so many people like there was no custody, dispute here. There was no pending divorce and a lot of people make false allegations in those types of cases too, so that they can get custody. But it's gross. And Christy says alcohol is toxic in almost any relationship. It is. You put two drunks like that together, what a mess. I mean, you could see what a mess it was. Every video that we saw, hammered by noon. Um, horrible, 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 horrible. There was never going to be a good end to this relationship. Somebody didn't have to die, obviously, but I just don't think this was ever going to end well. And they kept going back to each other. Drunk falling causes bruises too. That's true. This is true. Hi, Will. Hello. The dogs. Where are the dogs? One was blind, one was deaf. I think somebody said one of the dogs died. One of the dogs was in the video, and one of the dogs died. It's very sad. Two waves crashing into each other. Yeah. And I just maybe there's a lot of people out there who just don't who luckily have never had to deal with DV or know anybody who has. I've worked with so many clients that have been victims of so many things that I have a different perspective on this stuff. I think things are always a lot more complicated than they seem, than we can realize from looking on the inside, looking in from the outside. An addiction, and it's toxic, and the ripple effects are enormous on everyone. Everyone. I don't know, Mindy. What would you like? What would you like? I'm taking requests. Requests. What's the next case that's coming up that you would like to talk about? Let me know. Hey, Will. People want to know when you're going to have me on your show again. They're asking. Also, alcoholics have thin blood and they bruise easily. This is true. Haley said, I fought back once and he punished me by driving the car into a brick wall. Holy shit. I needed 2 major surgeries. I lied to cover for him. Were you able to get away? I'm going to put the DV hotline. Thank you for reminding me. Back up. 1-800-799-SAFE, 1-800-799-7233. There are many people in the chat who will tell you that it can be very, very life-saving and helpful to call that number. And they will help you with lots and lots and lots of things that you will need. A safe house. It's the great Ducky Charlie Brown. I don't think Sarah injured herself, but after watching the videos, I do feel she egged him on at times. Okay, so that begs the question. And I don't say that you're saying this. I'm just saying that if she egged him on or taunted him, did she deserve to get beat in return? That's kind of the way some people think. She poked the bear, so she got what she got. Too bad. I don't think a man should ever lay hands on a woman. I don't think anybody should everybody just, unless you're gonna, unless it's like a pat of affirmation, like egging him on, taunting him. So she deserved it. I'm not saying you're saying that, but I'm saying that I have seen comments like that. And so I'm asking you guys what you think. George did have injuries too. He did. Misha, I saw mostly passive men in those videos. It's all very confusing. And we talked about this earlier too. And I said to people, if you've ever been in a relationship with someone who's a raging alcoholic that was violent, right? Because not all alcoholics are DV perpetrators, and not all DV perpetrators are alcoholics. But let's just put, because this is what we have here in this case. We have alcoholism and we have violence. Does there come a point where the alcoholic reaches a level past which they will inflict a beating upon someone because they're just too hammered? That, I mean, when I looked at that video of him in the hallway, that's what it looked like to me. Yeah, we're on a break. We're waiting for them to come in. They were supposed to start at 1:30 with opening statements, and so it's 1:55. So what are they doing? I don't know, but we're not behind, right? This is real time. Sounded like the sound was up a little bit, but it's not again. And so I'm just asking, was he passive because he knew that he was being filmed? No. If she was choking him, he should just let her. No, I'm not saying that. But if he was choking her, should she not fight back? I don't know. I have a lot of questions in general, not just about this case, just opening up the dialogue to in general, I don't know. We weren't there. Should she go to jail? Yeah. She's been in jail for 5 years. I think she should go to jail for some more time. I think, when you got two alcoholics in a house together, it's a recipe for disaster. I wonder if they're working on a plea right now, says Zelda. I don't know. What do the cards say? What do the cards say, Zelda? I think she should have taken that plea deal. I don't think she's going to do better with a jury because when you put your hands in the fate of the jury, you are spinning the wheel. You're spinning the roulette wheel, in my opinion. Thank you. What the duckling says, I'm giving them a safe space to talk. Yeah, and also for people to learn. I think a lot of people are very closed-minded. They don't want to learn. It's just like, oh, this happened. Lock them up for life. That's it. Cold-blooded killer. I mean, a lot of people came into this trial, really. Like, first day of trial, she's a cold-blooded killer. I don't know. I tried to look at it like a juror with an open mind is all. Thank you. Thanks, What the Duckling, for recognizing that. We're waiting. We're waiting. Waiting forever. Simon Turner said, I watched George's family earlier. They spoke highly of him. The daughter described Sarah as the abuser. Also, he was a ladies' man. So sad. They also said she didn't let him communicate with them. So sad. Sarah has no family to speak for her, right? Well, except for the time is it where the court is? It is 1:57 here. They said they were coming back at 1:30. But it's right here, and I can see that I didn't put it on pause like sometimes I do because it's scrolling. And for those of you who said that Brian, her ex-husband, said that she was violent when she was drinking, did that come out during the trial, or was that something that you saw on another channel with some maybe body cam video or something? Because I don't remember him. He couldn't have testified to that. He wasn't called back on rebuttal, and none of the evidence of any of the DV was going to come in until the court ruled on it, until she showed an overt act, right? Cirque Lopez, at this point, if I was a juror, I would just focus on the day of the event. She said it was a good day. She said it was a good day. She said they were finger painting with his little fingers, and they were doing puzzles, and they were puzzled out. And that was a good day. And they were playing tag. Tag, you're it. And then the suitcase. And then this is why I have a hard time with this. I have a hard time with the self-defense, because using justifiable force for what? First of all, it wasn't deadly force, in my opinion. I mean, was it? I don't know. I have a lot of questions. And there's a lot of conflicting things here. No, it did not in court. It didn't. Right. Had that come out, why didn't they call him in their rebuttal case to say that she was violent with him too? Would have definitely helped, added to the state's case in any event. Colors Fight said no, it didn't come up at trial. Sarah has hidden. It needs to be. They're playing hide and seek, Andrea. Look in the shower. She likes to hide in the shower. Carol said he said that to the police officers in the apartment parking lot the morning of the 911 call, but they didn't play that tape, right? Because it may have been one of the days when I had to go run to the bus stop, and I may have missed it when you guys were watching and I wasn't. So please, if I missed it, tell me. She lies so much, I have a hard time believing when she tells the truth. I can't tell when she's telling the truth or when she's lying. Some people are so good at lying that they actually convince themselves that they're telling the truth. Narcissists. But both of those experts on both sides said that they did not diagnose her with NPD or narcissistic personality disorder, but that she had narcissistic traits. Lauren says, this is the best chat and channel ever. I've learned so much. Thank you. Thank you. That was a law enforcement webcam. It was on body cam. Not sure if it was in the trial. Yes, 100%. I'm with you. Every trial that we watch, I'm like, I don't ever put your life in the hands of the jury. Mark Betterow said that about Karen Reed's case. He said it should have been a bench trial, but not with this judge. If it was a different judge, could have been a bench trial, because jurors don't leave their common sense at the door. They do not leave their personal experiences at the door when they walk in to serve on a jury. So everyone's looks through other people's cases, other people's experience through a different lens. And you can try and put that away and be objective, but nobody can really be objective, really. Right? Joel said during his lunch break that the jurors wouldn't even look at her. That's interesting. That could go one of two ways. Right? You never know. I would never bet on a jury like that. Do they have odds in Vegas on this? Because I would never bet. And I would tell my clients, because I was a civil litigator. I'm in retirement now, hanging out with you guys, but let's say the client had a case and the case could have been questionable, because maybe the jury would have found against them or ruled them less or awarded them less money. When there's $1 million on the table, you got to really think about it seriously. Would you walk into a casino and throw $1 million down on the blackjack table and play one hand? Because that is what you're doing with a jury. That's what you're doing. I'm sorry. Please stop swallowing right into the mic when I take a drink. I'm sorry. Does it bother you? Okay. Thanks. Lindsay, that was in the statement to the police detectives, phone call and body cam audio. Was it admitted at trial? And was it said by the husband? Yeah, it is so frustrating that the Delphi case is not televised. The other case that's not televised that I may go for a couple of days of the trial, at least, is the Daniel Penny case in New York, the Marine who put the homeless man or undomiciled man who was on synthetic marijuana and acting erratically, threatening to kill people in a choke hold or sleeper hold, and he died. That case is in jury selection now. But in New York, we don't allow cameras in courtrooms. But the thing is about Delphi, that didn't they have some of the pretrial stuff that was televised? So I guess it's up to the judge, and the judge said no. Her own lawyer admitted that Sarah Boone's story changed from her psych evals to when she testified. She has zero credibility. Something is so funny, Auntie Bev. Max Bang, I did say she poked the bear viewing the videos this morning only because I couldn't imagine what would have happened if I taunted my abuser. Right. Right. But then I ask you, like, does alcohol give you more courage to do things you ordinarily would not do? She was hammered all the time too. Sunday fun day. Mm-hmm. Yeah. Prayers for duty, Ron. Paul says, Melanie, I'm so glad this is coming to a close. My prediction is guilty and a long, drawn out A. I can't see. What is her best? I can't see what that is. There's an emoji there. She sounded sober on the stairs. Is that the one where even when she was in the hallway, when he woke her up, that one? Not a Sarah fan, but credit where credit is due for what little time Owens had and how little Sarah gave him. He did a pretty good job defending her, much better than the pros say Sarah would have. I know. I know. Brian said her claws would come out. He wants them to go all night. I think he said 9, but he would ask for a special dispensation from the Chief Justice or something if they could stay past 9 tonight. Hey, D&E Pizza, Duck. Oh my God, Jen, that is one of the best screen names out there right now. Well done, well played. Hugs and a huge fight. Oh, the Hubs and I had a huge fight. That was the only time you did a puzzle. You had a fight over the puzzle. You got puzzled out quickly, eh? Clinton says, "Oh my God, I don't mind when you swallow drinks on the mic or when you play with your hair. Why are there so many complainers, really?" I was watching Emily Baker last night because I'm a huge fan of hers, and she plays with her hair a lot. And I never even noticed it until people started ragging on Allie and I about playing with our hair. And I'm wondering, like, well, I guess when there's 28,000 people in the chat, you don't really see the comments, but do people go into her chat and be like, "Stop playing with your hair, it's so unprofessional"? Thanks, Al, for your 5. I'm gonna quit. Note to self, I'll allow it. Oh, that's a good one, Debbie Joe. You have a burner account, or did you just change it? Note to self, make sure you have plenty of puzzles and don't run out. Yeah, and darts too. Make sure there's darts. Justice for George. It is a very odd case for sure. It's a lot different than I thought. I thought this was just going to be like one of those palate cleanser cases, like Tellus was. Tellus was actually. So there's that. But it turned out to be a lot different. It opened up a lot of conversations. It opened up a lot of it was thought provoking, I think. I think it was thought provoking in many ways. Just another manic fun day. All right, they're moving the camera. I think he did say the closings were going to be 3 hours, so maybe do they get 90 minutes each? If anybody knows, feel free to put it in the chat.
We're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. Limited appearances for the state, please.
Dave Cacciatore on behalf of the state. Will J for the state.
Defense.
Tony Owens for Ms. Boone. Tony Anderson for Sarah Boone. Kevin back over there.
Ms. Boone is seated at counsel's table wearing the same clothing from this morning. I apologize for my lateness. I realized that there were some typos after I'd sent this to print and needed to take them all apart to fix it. So thank you for your patience as we work through
Hey, proofreads, it's a judge after my own heart.
that. State.
We noticed that in the non-deadly force,
Page 12.
there was a couple strike throughs with the use.
I saw.
However, there was also a mistake with leaving a paragraph about reputation in at the very end of the 3.6G, and that should have been a mirror of the relative physical capabilities of the parties.
I do see that.
Other than that, I saw the he, she bracketed still,
I fixed that on page 16.
and then it's just that one, I think that Mr. Henderson and I noticed.
Okay, all right. I can have Madam Clerk start fixing them here.
I'm just going to pause that for a second because we're going to have time to catch up. Elf said if they didn't bring in Battered Spouse, we wouldn't have seen those videos. I know. Here's what she should have just gone with. I was hammered. It was stupid. I made a really dumb mistake and it was an accident. I did not mean for this to happen. And then maybe all that other stuff wouldn't come in and we'd be sitting here with a different case. I think it was I'm not a fan of the strategy. And maybe that's what those other 8 lawyers tried to tell her. And maybe she didn't agree to it. And that's why we're here.
Yeah, I think we should proceed and get going if we can.
But they will have nothing in their hands.
All right, well,
That's the issue.
all right, let's face that one.
Sorry. All right, thank you. Just give us a minute to fix all this. Yes, be fabulous. That I'm paragraph 2 where the
We have to talk about typos. I agree, Sandy.
so
Sandy
that
says
reputation paragraph should be removed.
Sandy says she was at the very least was negligent leaving him in there 100%. 100%. And this self-defense claim only comes in if she was in fear for her life. And I don't think that she can show that she was in fear for her life. I don't think that him sticking his hand out the suitcase was an overt act, which is why she should have just gone with it was a stupid thing, show a lot of remorse. Horrible. He never should have died. It was stupid of me. And tried to use that defense, which wouldn't have gotten her off, but at least it would have gotten her a little less than a murder 2 charge. Murder 2. I mean, I don't know. Maybe they would have seen it differently if they heard it that way.
I don't know why.
We don't know what they're going to
Correct.
do, of course.
Was there anything else other than that? If you find Jorge Torres had a reputation for being violent and dangerous person, you may consider this fact in determining whether he was the initial aggressor. Anything else that needs to be added to the jury instructions from the state side of the ledger?
Well, the reputation should be deleted.
Correct. I agree with you. Yes. I'm sorry. What the heck is going on here?
Yeah, thanks you guys for pointing that out. I think the state psychiatrist did
That's
say
correct.
something about Brian. We don't need to listen to them bicker. Hit the like button. It's a nice thing to do. Louise, if George had killed her in an effort to free himself, he would have had a good self-defense claim. Her self-defense claim is ridiculous. Yeah, I don't see it either.
Mr. J, was there another line that we had added to the end of that?
I don't believe so. The physical contact sentence is where it should be.
Okay. Maybe that's what I was making. Maybe that's what I was thinking of. So the sentence should read, in considering the issue of self-defense, you may take into account the relative physical capabilities and capacities of Sarah Boone and Jorge Torres. Is that
The delay is because they had a bunch of typos in the jury instructions, so they're working them out now, and they're reprinting the jury instructions, and then they're going to come back and do closings. Sorry for the delay. The judge was late. He was doing stuff with the typos and the things and the stuff. The only concern she has ever shown is for herself. She has never shown any remorse that I can tell. It would have been a better look for her to show some, especially now when she got up on the stand. Hi, Stephanie. The state psychiatrist did sneak in that Brian had said she was violent towards him. Specifically, she had read it in a police report, which made it hearsay and should have been objected to. So she did squeeze it in there. Squeak it in. Clinton says she's never seemed sad or upset about George's death. She seems so cold and selfish. Seb said real intent would be if she tried to dispose of the suitcase with the body inside. Yeah, like Brian Walsh, except trash bags, I think was his method.
I know there's a mic here. I know there's a mic right here.
I will confirm with
They care
court
about
admin that microphone is on. I believe it is. They turned it on during openings. I'll confirm now.
And the judge, last time I used this fingerprint table as my podium.
That's fine.
I may just slide it back so I'm.
That's fine, sir.
And then, Judge, I've got 2 tripods. And I've got some demonstrative aids. One is this, it was originally a quote by Dr. Michael Brannon.
Okay.
Okay.
And
May proceed. What are the other enlargements, sir?
It's it's the one I tried to get in.
I hear no
an
objection.
opening, which was the justifiable use of non-deadly force.
No objection.
Skylar, do you love the Tates or what? Was I right?
Reasonable doubt, I was using it for.
You've seen them?
I
Okay.
had no objection to those 5. I didn't like the 3 charts. The defense agreed that the 3 kind of reasonable doubt charts they won't use, so I think we're all good on your charts.
All right. Very good.
And the only other thing I want to use.
But we're good with their demonstrative aids during closings that we were used during trial.
Okay. Very good.
I've got 2 videos that I'm going to want to play, and Shelby Andrews is going to walk up.
They're in evidence, right?
They are.
Yep.
Okay.
One of them's been pared down.
That's fine. As long as it's in evidence, you can present whatever you'd like.
And Judge, do you want to talk about time for closing?
We can. What do you think, State? You advised an hour and a half.
Hilarious.
Yeah, I think we both said hour and a half, but as the court knows, you can't really hold us to it until it gets a little ridiculous.
That's true. How much do you anticipate, sir?
Well, Judge, she's charged with murder. We've had a 2-week trial. I've got a lot to say. I've got a lot of notes.
Oh, Sarah probably wrote his closing. Are you kidding?
Good. So,
Say again?
I'm not hearing any,
Okay.
Stammering clamoring from the state.
After the state has had their first opening, give them a
Agreed.
short break, and then let me start.
Agreed. We'll take our afternoon break at that point in time, then we can proceed with the defense closing and then rebuttal. I have received approval from the chief to work after 9 o'clock.
Oh, the
So,
chief.
We can go till about 10.
You gonna
maybe
get
a
him
little bit
pizza?
thereafter.
And then you're saying with the jury. And
Correct.
then at 10 o'clock, if we hit some number, 10 or 11, then when we come back Monday,
That's correct.
Delphi judge is working on Saturday. And remember, Ashley Benefield's jury stayed late too. They ordered pizza for them. And I'm just going to say, and don't hate me, Florida pizza is not all that. So, look at Hazel. This is a great Hazel Eyes. Great comment. Her little boy says, since hearing it during this trial, he tells me before school to remember to hit the like button or the Pop-Tart lady will turn the fan off. It's hilarious. Hilarious. I love it. We're child friendly here, see? Right. Right. Life on makeup. We wouldn't want to get to fix the typos. We wouldn't want the defendant zipped zipped the defendant into the suitcase, right? The defendant hit the defendant with her car. A la Karen Reed. Unetti and Jackson, corruption crushers, because she knew he was already beaten with the bat. Oh, that's who you're responding to. Okay. I'm confused. Blame it on the alcohol. Exactly. There are a lot of people who thought that Ashley was faking. A lot of people. I think all the people, except for maybe 2% of the people who watched that trial. He is. I think he's shown his lawyering skills, Mr. Owens. I think he's a good attorney, and I think he fought like hell for her. And that's what she deserves, and good for him. I don't think she's going to get out of it, but I think he did a great job with what he was given and what he had and with what I'm sure her demands were. Right? She got some courtroom snacks, but she didn't get the Pop-Tarts, right? She didn't get the mints. I don't know if she got any of that stuff. So what kind of snacks is she getting? Yeah, I think this is going to wrap today. I'm pretty sure we're going to be done with this today. Tara Christine, she called 911 so many times in the past. Why not at the time of the incident? Doesn't track with her theory. I know. I think because here's what I think. I think she was too embarrassed to admit that she was so hammered that she just passed out. I don't think she called 911 because I don't think she was in fear of anything. And you see throughout this case and throughout the body cam footage and throughout even her own testimony, how she minimized her drinking. And that is the thing. Many alcoholics minimize their drinking. They don't want to admit they have a problem. And until they want to get help, they're not going to get help. It has to be their idea. That's why you can't force them into recovery. And that's what I think. I think she was embarrassed to admit she just passed out drunk and completely forgot, blacked out that he was in there. She didn't even remember taking the videos. Chelsea says she said so many versions of her lie. She doesn't even know what story she has anymore, let alone remorse. If you're just tuning in, welcome. They have not started opening statements yet. They are just working out some typos on the jury instructions. And the jury has agreed to stay late until 10 p.m. They got special dispensation to keep the courtroom open past 9. So you haven't even missed a thing. Thunder Road Queen, if you're scared of someone, are you really going to video them? Moreover, are they going to let you? He did come for her when she had the camera in her hand. Thanks for the 10. We were just discussing this before. Like, is there a point where the alcoholic abusive person is so drunk that they can't hurt you? I don't know. Maybe she taped him then. But in every video there was, they both seemed hammered. I don't know. Thanks for your super chat. But seriously, what was the sound the neighbors heard? Yeah, ginger snaps. So, I mean, the two choices are her kicking him down the stairs in the suitcase, or him pulling her down the hair by her stairs because she said that's what happened. And that was a long ass flight of stairs. So, I mean, if she kicked him down the stairs, well, then no, the cause of death was asphyxia. So it was a lack of oxygen. It wasn't a brain bleed or anything. I was thinking if she kicked him down the stairs and he landed on his head, could have had a brain bleed. And that could have caused his death, but like in the Officer John O'Keefe murder. All right, they have their sound off now, so. I always thought lawyers should be called waiters because all you do is wait. Go to court, wait. Could take you all day. Sit in court all day for a 10-minute conference because there's like 100 cases on the calendar. Yeah, I don't know. I don't know what they heard, but those neighbors, I liked those guys. I liked those witnesses. I thought they were great. And I liked the neighbor too, Pearl. I thought she was great. J-Pop says, I can see after a few years have passed and you're basically fighting for your life, but you're not going to be bawling like the death happened yesterday. You're focused on your defense and saving you. No, I agree with you. I agree. But even like, I'm talking about like the lack of remorse, like even when right after she found his body and she's outside on the body cam footage talking to the police. like right away. She's not all broken up that he's dead. You know what I mean? She's not, or that she just found a dead body in a suitcase and it was purple. And I would imagine, I mean, I guess people process trauma differently, but I don't know, just weird. Out of Scope says the lack of any form of remorse is telling. People 100% justified in killing others still feel bad about it. I personally think she's criminally insane and desperately needs treatment. She is broken. Camera's grandma says if she had only recorded when he was threatening her, we might be thinking differently. Yeah. Jessica said when they recorded one another, reminded me of Johnny Depp and Amber Heard's case. Yeah. Maybe that's where she learned it. Amy, I wonder if her ex-husband has some relief from her craziness when she's been in jail. I wonder. She's not calling him 10 times a day, asking him to fix things in her life. And he doesn't have to wonder whether or not she's going to be sober enough to pick their son up from the bus stop. Right? Sarah Boone did take George out of the suitcase before calling 911, clearly cover up a crime. Well, she called her ex-husband, she called Brian even before calling 911 to come over and fix it, like he was some kind of Ray Donovan. And then he told her to call 911 like 3 times and she didn't do it. And like I was saying, like, why? she should have just left him on the floor and said, I came down and he was dead on the floor. I don't know. He must have gotten out of the suitcase and passed out. I don't know. Hit his head. And it was just, the whole thing is bizarre. Sentient dreamer. Sarah reminds me of my mother. She's also easily disliked. Neither of those add up to a sympathetic defendant for me. Murder 2 is too much. I'm glad you're thinking about it. Cindy, did they do this in the Karen retrial, or did the jury get Auntie Bev's instructions and told that's the way it's done in Massachusetts, Mr. Jackson? They did get, I think, a copy of the jury instructions to bring back with them, but she did tell them after reading the instructions to them, she said, here's a copy of the jury instructions for you, but whatever I told you takes priority over what's actually in the written instructions. Like, it was just very, very confusing. Oh, I don't know if Mr. Cacciatore is back in his waistcoat today, because that is like the tan suit that has the waistcoat. I'm here for it. I love that waistcoat. It's very Bridgerton to me. Jessica says she got lucky with Owens. Yes, he answered her ad. He answered her call. Their sound is still off. Sherry, are those people behind the judge's security team disguised as interns with Sarah on the loose? They're law students at the law school where he teaches, and I think they're part of the mock trial team. And they're very lucky. I mean, this is a historical case. I mean, because it's televised. Think about all the cases every day that are far more important than this one that aren't televised, that nobody gets to see. Amy, the last videos were just insane where she was coaching him to say all those nice things about her, right? JD, dude, Tate's chocolate chip cookies. They have a lot of other flavors too. Their coconut ones are really good. Tate's is dangerous and divine. I have to eat the gluten-free ones, and those are just straight up magic. Are they good? I thought maybe the gluten-free ones would taste like cardboard. But yeah, they started right out here on Long Island in Southampton. They had a little tiny bakery. Tate's, if you know, you know, best chocolate chip cookies, in my opinion, out there. They sell them in Costco now and some other supermarkets and other places. Oh, you like them? Good. I'm glad you took my recommendation. People like my TV show recommendations too. I'm thinking maybe I'll get away from something that's so divisive like this and, you know, cover entertainment stories instead. I can't swallow near the mic anymore.
State, are you ready to proceed? Defense, are you ready to proceed?
1 minute.
Yes, sir.
I might have to go take a ride while light starts and get some. I don't think she did CPR either.
We're ready, Judge.
All right, let's go ahead and bring in our jury.
It is like story time.
Yeah, that would be fabulous.
Oh, hot mic moment.
Bruce. Oh, I do not. The jury.
All right. Don't whisper into the mic. I know. Can you imagine if Alan Jackson had 90 minutes? Think about that. This trial is 5.5 days long. And they get 90 minutes. Karen Reed's trial was something like 60-something days long, 9 weeks, and they got 1 hour to close. Ridiculous. Oh, you didn't like them? I like them because they're crispy. I don't like chewy cookies or ones that seem overly processed. To me, they were the most homemade ones that are out there on the open market, if you ask me.
Jury entering.
Tate's are on sale at Target if you want to try them. Thank you, Terry. We like sharing secrets here.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
Everyone can be seated. Thank you. Members of the jury, thank you for your patience. We had a long conversation about the jury instructions, and I missed a typo or two after I had printed everything, and it took us a while to print everything out. I'm going to ask the courtroom deputy to come forward and pass these out to you. If you could, if you can, please raise your hands to confirm that you complied with the court's instructions during the break. All right, record reflect all hands have been raised. Members of the jury, we are at the conclusion of the evidence and testimony in this case. The court is now going to instruct you on the law. The courtroom deputy is providing you copies of the jury instructions. Like I said at the beginning, you're going to be able to take these back with you into the deliberation room. There's not going to be a quiz or a test at the end. You don't need to memorize anything. If you'd like to read along, you can. If you just want to listen, you can. It's completely up to you. The court's going to read most of the instructions and then turn it over to the lawyers for their closing arguments. The state will go first, as they have the burden. Then the defense will go. And then the state will have the opportunity to rebut. Then I will conclude the instructions and release you for your deliberations. After the state's closing, we're going to take our afternoon recess. At that point in time, I'll have the courtroom deputy provide you that emergency number. So if you need to reach out and to family or loved ones to let them know that you are on the jury and are deliberating, you can do that at that time. With that, members of the jury, the court's going to go ahead and begin reading you the jury instructions. Instruction 3.1, Introduction to Final Instructions. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give to you. 3.2, Statement of the Charge. Sarah Boone, the defendant in this case, has been accused of the crime of second-degree murder. 7.1, Introduction to Homicide. Sarah Boone is accused of second-degree murder. Murder in the second degree includes the lesser crime of manslaughter, both of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Jorge Torres was killed by Sarah Boone, you will then consider the circumstances surrounding the killing and deciding if the killing was second-degree murder or was manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual, ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and as such, does not include mere bruises. I now instruct you on the circumstances that must be proved before Sarah Boone may be found guilty of second-degree murder or any lesser included crime. 7.4, murder, second degree. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, Jorge Torres is dead. 2, the death was caused by the criminal act of Sarah Boone. 3, there was an unlawful killing of Jorge Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill, or to...
Okay, so listen up to this because this is important. This is for all of you who are saying second-degree murder. This is what they have to show under the depraved mind part of second-degree murder. Was that act imminently dangerous, leaving him in the suitcase? Okay, listen. Hi, Kelly Reed. I'm going to put your popcorn fundraiser in the chat. So if anybody would like to buy some popcorn so that Kelly Reed can win the contest against all the other guys that are in the contest, you will be supporting the Karen Reed Defense Fund. I'm going to stick it in the chat and then pin it. If you would like it, it'll be there. Thanks.
or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. 3.4, when there are lesser included crimes or attempts. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is charged, there may be evidence that she committed other acts that would constitute a lesser included crime or crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of second-degree murder is manslaughter, culpable negligence. 7.7, manslaughter. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, Jorge Torres is dead. 2A, Sarah Boone intentionally committed an act or acts that caused the death of Jorge Torres. B, the death of Jorge Torres was caused by the culpable negligence of Sarah Boone. Yes, I apologize.
He's
Or thank you
mumbling.
for that clarification.
Oh.
Sarah Boone I'll reread those for you. 2A, Sarah Boone intentionally committed an act or acts that caused the death of Jorge Torres. Or B, the death of Jorge Torres was caused by the culpable negligence of Sarah Boone. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Capable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise.
Okay, there's no evidence that she beat him with the bat before putting him in the suitcase. So let's just not post misinformation. That's not the testimony. The testimony is that she said she took the bat and poked him with it, poked his hand back in. We don't have any other evidence to contradict that.
The presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. 8.9, culpable negligence. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. 1, Sarah Boone exposed Jorge Torres Jr. to a personal injury. 2, she did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life, or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such indifference to the rights of others as is equivalent to an intentional violation of such rights. 3.6D, as in Delta, voluntary intoxication. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that she lacked the specific intent to commit any crime. A person is voluntarily intoxicated if he or she knowingly consumed a substance that he or she knew or should have known could cause intoxication. Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence. 3.6F as in Foxtrot, justifiable use of deadly force. It is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone constituted the justifiable use or threatened use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Sarah Boone does not have the burden of proving that she was justified in using deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using deadly force. The law on the justifiable use, deadly force, is as follows. Sarah Boone was justified in using deadly force if she reasonably believed that such force or threat of force was necessary to prevent imminent death or great bodily harm to herself. Sarah Boone had no duty to retreat before using deadly force. In deciding whether Sarah Boone was justified in the use of deadly force, you must consider the circumstances at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed the use of deadly force was necessary. Moreover, to justify the use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself, unless 1. The threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm.
Uh-oh.
Please silence your cell
Somebody has a
phones.
phone on.
And had it exhausted every...
Again.
Out. Whoever phone is on, get out right now.
Ooh, he's not playing. That is really bad. That's in poor form.
Members of the jury, I apologize. I'm going to read that over for you for the beginning. Paragraph 1.
I'm just not seeing deadly force here. I'm having the disconnect with deadly force, you know?
The threat of force asserted toward the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm, and had exhausted every reasonable means to escape the danger other than using deadly force on Jorge Torres. Or 2, in good faith, Sarah Boone withdrew from physical contact with Jorge Torres and clearly indicated to Jorge Torres that she wanted to withdraw and stop the use of deadly force. But Jorge Torres continued or resumed the threatened use of force. Physical contact includes any restraint on Jorge Torres's movement. If you find that Sarah Boone, who because of prior threats or difficulties with Jorge Torres Jr., had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of Jorge Torres, you may consider this fact in determining whether the actions of Sarah Boone were those of a reasonable person. If you find that at the time of the alleged second-degree murder, manslaughter, or culpable negligence, Sarah Boone knew that George Torres had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres.
I'm missing page 10 and 11.
I am too.
Oh, no. Missing pages. Oh, no.
We will remedy that. Thank you, sir. Is it just your copy, Mr. Owens?
Anybody else missing 10 and 11?
Somebody get back to the Xerox machine.
Mr. Owens, approach, sir.
Great way to support the channel. It doesn't cost you anything. Just shop through my Amazon link and buy whatever you normally buy from Amazon. Doesn't cost you any more. Doesn't cost you a thing, but it's a great way to support the channel if you want. Thanks, Sarah, for putting the link up. It's also in the video description or the show notes.
Thank you. Record reflect all thumbs were up. Page 11, special instruction on battered spouse syndrome. You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse syndrome. 3.6G, justifiable use of non-deadly force. It is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone constituted the justifiable use of non-deadly force. Non-deadly force means force not likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Sarah Boone does not have the burden of proving that she was justified in using non-deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using non-deadly force. The law on the justifiable use of non-deadly is as follows. Sarah Boone was justified in using non-deadly force against George Torres and had no duty to retreat if she reasonably believed that such conduct was necessary to defend herself against George Torres's imminent use of unlawful force. In deciding whether Sarah Boone was justified in the use of non-deadly force, you must consider the circumstances at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use of non-deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed the use of non-deadly force was necessary. Moreover, a reasonably cautious and prudent person under the same circumstances would have believed the use of non-deadly force was necessary. However, the use of non-deadly force is not justified if you find that Sarah Boone used force to initially provoke or threatened use of force against herself, unless one, the threatened force asserted towards Sarah Boone was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using non-deadly force on George Torres. Or 2, in good faith, Sarah Boone withdrew from physical contact with George Torres and indicated clearly to George Torres that she wanted to withdraw and stop the use of non-deadly force. But George Torres continued or resumed or threatened use of force. Physical contact includes any restraint on George Torres's movement. If you find that Sarah Boone, who, because of prior threats or difficulties with George Torres Jr., had reasonable grounds to believe that she was in danger of imminent use of unlawful force at the hands of George Torres Jr., you may consider this fact in determining whether the actions of Sarah Boone were those of a reasonable person. If you find that at the time of the alleged second-degree murder and/or culpable negligence, Sarah Boone knew that George Torres Jr. had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use non-deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres. Special instruction on battered spouse syndrome. You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse syndrome. 3.7, plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. 3.9, weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court. Whether the state met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of her testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. 3.9 Bravo, defendant statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, 1, whether, when the defendant made the statement, she had been threatened in order to get her to make it, and 2, whether anyone had promised her anything in order to get her to make it. Law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. 3.10, rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this matter. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence in these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict.
Hold on. Did he say they're going to do sentencing too? Hang on a second.
4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a
Okay.
proper sentence if the defendant is found guilty.
Okay, so in the Carly Gregg trial, the jury went back for the sentencing phase and the jury sentenced her to life with ever having the possibility of parole. She was 14 years old. In this case, the judge decides the sentence. Okay.
6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. 3.11, cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. 2.7, closing argument. Both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. With that, state, you may proceed.
Okay, this is the state's closing argument coming up next. He's got the suitcase. Oh, he's got the waistcoat on. Wait, if you're not looking at the screen, come back. Come back. Prosecutor Daddy has his waistcoat on today. Something to look at. Okay, here we go. I think it's a good look. I'm just saying. I like the way he tossed the gloves.
This is a box. This is the box where Jorge Torres was killed. It's a small box, 28 by 20 by 8 7/8 inches. Jorge Torres was zipped up in this box. Jorge Torres took his last panicked breaths in this box. The medical examiner explained to us that with each breath Jorge Torres took in, there was less oxygen in this box. Jorge Torres was murdered in this box. Ladies and gentlemen, on behalf of myself, my trial partner, we thank you for your time and attention in this most important of trials. We now have the law from the judge in this case. This is what our duty is to follow. And let's have a discussion regarding that law that we've just been read and given. The first section of note we're going to come to is called Introduction to Homicide. But this being a legal document written by a bunch of lawyers who you've seen for the last 2 weeks arguing with each other, pay careful attention to ands and ors. Remember, if an and is somewhere, we're going to need both things or all the things, and if an or is there, then only one of those things we're going to need. So as we start out here on Introduction to Homicide, we come to the first section on justifiable homicide. And it reads, the killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time. Ladies and gentlemen, this section is completely inapplicable. It's inapplicable because Jorge Torres was zipped up in that suitcase. He couldn't commit or attempt to commit a murder on anybody. He couldn't even scratch his own head while he was in that suitcase. Next, we turn to excuse.
About this a lot, and this is what a good attorney does. They go through the verdict sheet and the jury instructions with the jury. If they have time, they've got 90 minutes each for closing. They've got time. Because like you've all said, I wouldn't understand these instructions. I have no idea what this means. He's walking them through it. And he's saying, this is why justifiable homicide, you should just cross it off, because he was locked in that suitcase and he couldn't get out. He couldn't have done anything to her. So this is an excellent strategy that a lot of very good trial lawyers use, and it really helps them understand what they're going to talk, what they need to decide when they go back. Karen Reed, they didn't have time for this. They only had an hour.
Homicide. Here we have several paragraphs, and it reads, the killing of a human being is excusable and therefore lawful under any one of the following three circumstances. When the killing is committed by accident and in misfortune in doing any lawful act by lawful means, usual, ordinary caution, and without any unlawful intent. Well, the problem in this circumstance for the defendant is that she took the law into her own hands. Her testimony was that when Jorge Torres was in here, he was laughing and giggling and they were joking. And then he started to complain that he couldn't breathe. And that's when she said that she wanted him to stay in there so he could feel uncomfortable. So he could feel her grievances. Ladies and gentlemen, that is not lawful. That is not the use of ordinary caution. And that is not applicable in this circumstance. Second, when the killing occurs by accident or misfortune in the heat of passion upon any sudden and sufficient provocation. Jorge Torres couldn't provoke anything from his circumstance. Jorge Torres was confined to this box. Next, when the killing is committed by accident and misfortune resulting from a sudden combat, a dangerous weapon is not used, the killing is not done in a cruel and unusual manner, Well, this fails on 2 counts. There was no sudden combat. In her words, this was laughing and joking, and we're all having fun, when she decides that it's going to get a little extra real for Jorge Torres. And it fails on the 2nd count because Jorge Torres was killed in a cruel and unusual manner. Next, we turn to our main charge of 2nd-degree murder. And the law informs us that to prove the crime of 2nd-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. And I think it's important to stop right here. This sentence right here is telling us what has to be proven in order for the crime of 2nd-degree murder.
They just froze their feed. Hold on.
One fact that conclusively proves each of those elements beyond all doubt. As to the first fact, that Jorge Torres is dead, well, we have stipulation, amongst other things, that agrees to that. As to the second fact, the death was caused by Sarah Boone. Sarah Boone, in her own words, from the time that this case began on February 23rd, 2020, to when she took the witness stand a few days ago, was consistent about one statement. She zipped him up. She didn't zip him out. She zipped him up in the suitcase, and she refused to zip him out. 3, there was an unlawful killing of Jorge Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. The law goes on to define for us what a depraved mind is, and also what an act is. And it's going to tell us that an act includes any series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or a series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily harm to another, and is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself displays an indifference to human life. Ladies and gentlemen, her conduct fits every one of those things. And if there was a scintilla of doubt that this was not the actions of a depraved mind, I point to you, ING 1062, and states 17. Mr. J, may you publish states 17?
Oh, the family left the courtroom, Jules? That's interesting. Here's the video. Great question.
For everything you've done to me. For everything you've done to me. Fuck you. Fuck
Beep.
you. Stupid. That's my name. Don't wear it out. I can't fucking breathe, babe.
Also important to point out that it's upside down. So could he have gotten himself out? I don't know.
Yeah, that's when you do it. You choke me. Cheryl.
Yeah, we were a little bit behind. That's why I didn't understand that they left when this video was playing. Their volume just stopped. Oh, I guess. So now they're going to show the family leaving? That was nice that he took a break to let them leave. They left after the video was played. And they cut the sound. Judge Dewey K. Arthur in Mississippi told anybody in the gallery that if they showed any amount
You
of
may continue.
emotion when the verdict was read, that they were going to go to jail for contempt. It's crazy. This is not the verdict, but this is very disturbing to the family, understandably.
Cheryl. Cheryl. Sarah, I can't breathe it. That's on you. Sarah, I can't breathe. It's on you. Sarah. Real ransom. And now you want to give it for it extra. Because I got this. Sarah. Real ransom. I can't believe it. Oh. That's what I feel like when you drink on me. Sarah. Fuck you. Please, Sarah. Yeah. You should probably shut the fuck up.
Ladies and gentlemen, that exhibit removes any scintilla of doubt about the depravity of the defendant's actions. But we know from the evidence that this was not the first time she had considered killing Jorge Torres. We know from the evidence that on January 13, 2020, approximately 1 month prior to Jorge Torres' murder.
Jules says that George's mom collapsed hearing George. That's why they stopped. Thanks, Jules. Jules is our eyes and ears inside the courtroom. People said they thought you were home today, but I guess you're there. Okay, these messages were 1 month before.
2020, approximately 1 month prior to George Torres's murder. The defendant had a text message conversation. Please do something with yourself, Sarah. God bless you. And bless you and all of you too. I'll get rid of him, then I'll be better. Torres. But ladies and gentlemen, in this case, the law actually specifically tells us that the intent to cause death is not necessary. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death.
It's a good distinction. He's doing well. He's doing really well. Maybe I'm biased.
Next, we turn. I'm going to bypass the lesser included offenses because though she is guilty of those offenses as well, the law instructs us that she is to be convicted of for the highest offense in which the evidence supports, which is second-degree murder in this case. So turning our attention towards voluntary intoxication. If there was any question about the fact that Sarah imbibed alcohol on the night that George Torres was murdered,
This is his moment. He wrote this closing. Sarah imbibed. Sarah slammed it down. All right, we got to laugh sometimes or we'll cry.
and that maybe somehow that would excuse the conduct or be some type of defense for the conduct.
Exactly.
Well, this tells us that that's not the case. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that she lacked the specific intent to commit any crime. A person is voluntarily intoxicated if he or she knowingly consumed a substance that he or she knew or should have known could cause intoxication. Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence. Ladies and gentlemen, there's ample evidence of the defendant's intoxication from watching her on the public surveillance, buying the bottles of wine with George Torres, to her admissions to drinking, to her voice that we heard on the video while she was torturing George Torres. Next, we come to defenses. First, we come to the justifiable use of deadly force. It tells us it is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone were justifiable use or threatened use of deadly force. Sarah Boone does not have the burden of proving that she was justified in using deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using deadly force. The law on the justifiable use of deadly force is as follows. Sarah Boone was justified in using deadly force if she reasonably believed that such force or threat of force was necessary to prevent the imminent death or great bodily harm to herself. Sarah Boone had no duty to retrieve. Ladies and gentlemen, in a few moments, Mr. Owens will rise, and he is going to show you this. And this. And this. And he's going to talk, and this as well, about the list of grievances that Sarah Boone had for Jorge Torres. He's going to talk to you about curtain rods. He's going to talk to you about black eyes.
Don't minimize it. Don't minimize it.
He's going to talk to you about what an awful, awful boyfriend Jorge Torres was. And ladies and gentlemen, at the end of all of that, it still will not change the fact that the defendant is not entitled to the justifiable use of deadly force. Because as we continue to read this instruction, it tells us in deciding whether Sarah Boone was justified in using the use of deadly force, you must consider the circumstances at the time the force or the threat of force was used. Danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed that deadly force was necessary. Moreover, to justify the use of deadly force, and this is important, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. Ladies and gentlemen, no reasonably prudent and cautious person would believe that a man who could barely fit into this box, who was incapable of movement, who was begging for his life, who was slowly asphyxiating, suffocating with each breath, would have needed to use deadly force against him. The justifiable use of deadly force utterly fails, utterly crashes like a house of cards. But there's more. However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke threatened use of force against herself. Let's stop there before we consider the next two paragraphs. Some of the most critical testimony in this trial is her testimony on the stand. It was a great day. We were doing puzzles and artwork, dancing with the dogs, listening to music. Tag, you're it, hide and go seek time. George gets into the suitcase. She comes and zips him up. They were still laughing about it. We're still laughing after he's zipped up in the suitcase. And then that's when George had the temerity to ask, Jorge Torres had the temerity to ask to be unzipped from the suitcase. And that's when Sarah Boone decided he needed to suffer. She was the initial aggressor, ladies and gentlemen. She provoked the use of force in this case. In her own words, we were laughing and playing right before he wanted to be let out because he couldn't breathe. Paragraph 1. The threat of force asserted toward the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger, other than using deadly force on Jorge Torres.
I'll allow it, Deborah. It's a waistcoat.
He
Not even a
couldn't
vest.
exert anything, ladies and gentlemen. Jorge Torres couldn't even exert his arm out of the suitcase. How on earth could he have exerted a force so great to justify his
Judge, I object.
Approach.
See where he was going with that?
so great? Could he have exerted a force so great to justify his
Judge, I object.
arm out of the suitcase? How on earth could he have exerted a force so great to justify his
Judge, I object.
Approach.
Something about if he could barely get his hand out of the suitcase, how could he have exerted a force on her? I don't know what the objection is, but he's allowed to argue. He's no Jackson. It's true. He's no Jackson. But who is? But who is?
this
Objection overruled.
World.
this is of no help to the defendant. Second paragraph. In good faith, Sarah Boone withdrew from physical contact with Jorge Torres and clearly indicated to Jorge Torres that she wanted to withdraw and stop the use of deadly force. But Jorge Torres continued or resumed threatened use of deadly force. Ladies and gentlemen, Jorge Torres never got a chance to do anything. Jorge Torres never was able to mount any aggression towards the defendant. Therefore, this paragraph is inapplicable. And the law tells us as well that physical contact in this case includes any restraint on George Torres's movements. The law also tells us, again, you find that Sarah Boone, because of prior threats or difficulties with George Torres, had reasonable grounds to believe that she was in danger of great bodily harm, of death or great bodily harm at the hands of George Torres. You may consider this fact in determining whether the actions of Sarah Boone were reasonable. Now, we're going to get to battered spouse syndrome in a moment. But again, I submit to you, this will be the opportunity for the defense to air grievances in regards to George Torres. But again, those grievances will not change the law, and they will not change the fact that the justifiable use of deadly force fails as a defense for the defendant. If you find that at the time of the alleged second-degree murder, manslaughter, culpable negligence, Sarah Boone knew that George Torres had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. Considering the issue of deadly force, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres. Now we come to the the special instruction on battered spouse. You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find Sarah Boone suffered from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether, in Sarah Boone's circumstances, would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony in regards to battered spouse. Ladies and gentlemen, we've heard from 3 experts in the areas of battered spouse in this case. I think at the outset, it's important to note what battered spouse is and isn't and what the law instructs us here. Battered spouse is not some carte blanche. Battered spouse is not a license to kill. The fact that George Torres at points mistreated Sarah Boone, did things that were worthy enough to get him arrested, to get restraining orders placed upon him, doesn't mean that she walks around with an ace in her pocket when it comes to George Torres. It doesn't mean that because he did these awful bad things, that now through the rest of time, she's a battered spouse and she just has the right to kill him, or to make him suffer, or to punish him, or to make him feel uncomfortable, or decide that he needs to be confined to a box. No. What the battered spouse syndrome instruction does is it talks about the imminency of fear. And when we heard about that testimony, we heard about it from Dr. Harper, and we heard about it from Dr. Brannon for the defense. And some of the testimony was a little difficult to understand at points, but there was one point in Dr. Brannon's testimony that was very critical. Dr. Brannon talked about rule-outs. He talked about the fact that when emotions and emotional reactions are involved, like trauma and trauma-based disorders, other possibilities have to be ruled out before we can even ascribe those actions to battered spouse syndrome. Other possibilities, according to Dr. Brannon, include alcohol abuse. Dr. Harper should have listened to Dr. Brannon's testimony, because Dr. Brannon completely undercut Dr. Harper's testimony. Dr. Harper relied heavily on the words of the defendant, who was abusing alcohol at the time of these events. And then you heard from the expert for the state, Tanya Warner. And her opinion was much more straightforward. Remember, Dr. Brannon did not render an opinion as to whether or not she suffered from battered spouse. Dr. Warner said affirmatively, yes, I believe she did suffer from battered spouse syndrome. But she also applied what Dr. Brannon was talking about. Other possibilities have to be ruled out as the trigger for a behavior, for an event. So, in Dr. Warner's estimation, the fact that at the time of this incident, they were laughing and joking and carrying on meant that the trigger was not domestic violence or some threat. In the defendant's own words, the trigger was him wanting to get out and her being reminded of the bad things that he had done to her. That's not imminence of fear. That's a reminder of bad things a person has done. And again, even if you were to believe that she was battered spouse triggered at the time of this event, it still does not save the day. Because all the battered spouse trigger law tells us is that it goes to that imminency requirement. It doesn't say there's no imminency requirement. It doesn't say that, look, if you're suffering from battered spouse and you're triggered by battered spouse, then, hey, there's no more imminency requirement, do as you wish. It just gives the ladies and gentlemen of the jury another thing to consider in determining whether or not that threat was imminent. And we know from the evidence, we know from the videos, there was absolutely no threat. And we know there was no threat because Jorge Torres never got out of that box. He was never got out of that box until sometime on the early afternoon of February 24th. Mr. J, can you please publish from stage 21?
I'm gonna go to court and I'm gonna tell the judge, listen, my fiance has nothing to do with this. It's all my fault. We were both drinking and got out of hand. It's an isolated situation. It has never happened before. I love my fiance. She's a good woman.
The closed caption is saying Beyonce. And I think he's saying fiance. Oh, man. I'm listening like, is he calling her Beyonce? Okay. Bet settled.
For being in trouble in her life, she has a 7-year-old son that she loves and cherishes.
A blind Boston Terrier.
She has 2 dogs. One is blind and one is deaf. She goes around and she's driving and sees an animal that's injured. She'll stop in the middle of the street, no matter what kind of traffic it is, just to make sure that that animal doesn't get injured any more than what it already has. We both love each other. We both live together. Yes, every relationship has their arguments, but we are not the type of people that you guys are portraying us to be.
She especially
her. So please, if you can,
dismiss
this case.
Closed.
Drop it. She is not the type of person.
Good person.
Great.
Totally coaching him.
Angel.
I know she'd be an angel. She's close to it.
Best thing that has ever happened to you.
Yes, ma'am. And I love you to death. And I hate that we're going through this right now.
Sonnet.
What?
And it did.
Good, I love you. Whatever you want me to say. God will prevail and He will take us out of this situation. Love you.
Clearly, Jorge Torres is dominating the defendant. Clearly, Jorge Torres is the one telling the defendant what to do. Clearly, Jorge Torres is the one calling the shots at 4748 France Lane. Ladies and gentlemen, are we so sure that Jorge Torres wasn't the person suffering from battered spouse syndrome? Next, we're going to come to the justifiable use of non-deadly force. The language and the arguments are pretty close to what we've already heard in the deadly force instruction, including the key language that it requires a reasonably cautious and prudent person under the same circumstances would have believed that the use of non-deadly force was necessary. Ladies and gentlemen, I submit to you that this was not a case of non-deadly force. Jorge Torres lost his life as a result of these actions. We have heard the testimony of Dr. Sarah Zadovich, who described his cause and manner of death, who described the mechanism of death, how that oxygen dissipated in that suitcase. And when we also look at the imminency, we heard in opening statements by Mr. Owens that, the big threat in this case, the awful threat, was in the magic 9 minutes between the video at 11:12 that she took, torturing Jorge Torres, to her follow-up video at 11:23, after she had moved the suitcase. Mr. J, that you published from States 17, IMG 1063. It was a short video. But what's one of the things that we notice by this point? You can hear how loud George's voice is on the 11:12 video. But now, roughly 11 minutes later, from the time that started, you see that the makeshift coffin that he's in has been moved.
The makeshift coffin. The makeshift coffin. How does that land with you?
And his voice now is softer. The life is draining from Jorge Torres, and it's evident in that video. And that, ladies and gentlemen, is evidence that there was no threat in the magic 9 minutes that was not recorded. There was only Jorge Torres in this box, slowly being killed.
That's good. End there. That's good. That's a good ending. Think he's done? Sometimes long isn't good. See, I don't think that there's like,
Next.
see, it's like, I don't feel like this case is that complicated. I don't feel like he needs to go on forever. I think that was a powerful argument and it could end there. But we're going to go on.
We come to weighing the evidence. This instruction tells us it is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witness acted as well as what they said. Some things you should consider. Did the witness have an opportunity to see and know the things about which the witness testified?
I'm sorry that I have to interrupt this stream, but it has just been reported as of 4 minutes ago that Phil Lesh, the co-founder of the Grateful Dead and bassist, has died at age 84. Phil Lesh of the Grateful Dead has died. I remember where I was the day that Jerry died. Very sad. I know that he was a transplant recipient, and I'm not sure right now what his cause of death was, but that's what I'm interrupting to say. Rest in peace, Phil Lesh. And thank you for bringing me so many years of amazing music throughout the course of my life, the soundtrack of my life.
In focusing on the defendant, absolutely. Two people walked through the front door on the evening of February 23rd, 2020 at 4748 France Court. Jorge Torres and Sarah Boone. But only Sarah Boone ever walked out of that front door alive. Did the witness seem to have an accurate memory? This is an emphatic no. And the litany of her intoxication in versions of events is evidence of that. Was the witness honest and straightforward in answering the attorney's questions? I would submit to you she wasn't. 4, did the witness have some interest in how the case should be decided? Clearly. Does the witness's testimony agree with the other testimony and other evidence in the case? And I would say largely no. Because on the issue of whether or not Jorge Torres could have threatened her the way she says that he did, the answer is clearly no, and we know that from the forensic data. We know that from the items itself. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? In regards to the defendant, it's almost more appropriate to ask about the time she did make a consistent statement. You listen to her version of events on the 911 call, on the body cameras, on her first interviews with law enforcement, and then you hear her in her next interview the next day with Detective Copsell and Detective Lowen. and more details come out. Things change. First, she was never intoxicated, then she was intoxicated. Then there's just the whole fact of she omits the fact of, oh yeah, he was actually trying to attack me. Oh yeah, I was in fear for my life. When she said at every turn, no, it was just a great day. We were having fun. Oh my God, I can't believe this. We were doing good. The only stress we had was about jobs. And now, 4.5 years after the fact, it's time to come up with a new story. But ladies and gentlemen, I submit to you that the truth does not change. The facts do not change. The videos do not change. And on any version of events that the defendant has given, they all add up to the fact that there is absolutely no doubt that she is guilty of murder. I ask you, ladies and gentlemen, do you have any doubt about the defendant's guilt? When she described using that baseball bat to hit Jorge Torres's fingers back in the suitcase when he attempted to save his life. Do you have any doubt? When she is given how many versions of events in this case? Do you have any doubt after hearing the testimony of her neighbors about the loud crash and the arguing that night? Do you have any doubt after hearing the testimony of Dr. Sarah Zagovich? Do you have any doubt after watching the videos of Jorge Torres being murdered and her laughing about it and talking about the fact that he cheated on her? Do you have any doubt after reading the text messages from her phone? After seeing the videos of how she controlled and manipulated Jorge Torres? And if you say, Mr. Cacciatore, I still have a doubt. Well, then the law asks you, is that doubt to an element? And is that doubt a mere possible doubt, a speculative, an imaginary, or a forced doubt? I submit to you the idea that she had to do this because she was a battered spouse is an imaginary doubt. It's a doubt born from the imagination of Sarah Boone. It is not a reasonable doubt. But if you find yourself back in that deliberation room and you are just trying to think of some way in which the defendant is not guilty, just searching, struggling for that way, that also is not a reasonable doubt, ladies and gentlemen. That is a forced doubt. Ladies and gentlemen, I'm confident that when you read the entirety of those jury instructions and apply the law to the facts that came out in this case, that you are going to come back with the only lawful verdict, which is guilty as charged, second-degree murder. Thank you.
Members of the jury, it is 4:04. As I promised, we were going to take that afternoon break before the defense proceeds with their closing argument. You're going to leave everything behind. Similar instruction that I've given you before. Please don't conduct any independent investigation, research as to the person, places, thing, or charge involved in this case. And do not have any discussions among yourselves or anyone else. We'll bring it back in about 15 minutes. Thank you very much.
All rise, jury exited.
Okay, we are also going to take our afternoon break.
In compromise.
Wait.
Y'all may be seated. Thank you.
Judge, I've got a motion.
Okay. May proceed.
Motion.
Sarah Boone's entitled to a fair trial. I think that right has been compromised here today. I don't know who scheduled to put the 2 detectives on the front row with the Torres family, with the family of the victim. But they had to have known to tell them that the suitcase video, which has been around for 4.5 years, was going to be played during the opening statement. And the state attorney's office,
He's arguing
the
that
sheriff's department had to advise.
she did not get a fair trial because as we said, Detective Goddison, Detective Mr. Bigger, sitting with George's family in the courtroom, and they knew that the video was going to be played, and he thinks her right to a fair trial was compromised. So let's listen to his argument and see what it says.
And the state attorney's office or the sheriff's department had to advise them, or the victim's advocate had to advise them that if they couldn't take it in front of a jury that's trying to decide the case, they needed to get out of the courtroom. Now, what happened here today should not ever happen.
Very dramatic with his
There
hands.
should be safeguards in place. There's no room for this after 2 weeks of murder trial.
A lot of you said that.
For something like that to happen. One of the Torres members of the family audibly, during the 2-minute suitcase video, expressed some kind of emotional reaction. I look back, he or she were bent over in agony, physical pain. The physical pain followed the audible announcement. You can't unring that bell. That's their responsibility.
There are many judges that will say that if anybody in this courtroom is going to be overcome by emotion, they should leave the courtroom. And it's very common that judges do instruct that. You know that because you've watched other trials with me. You watched Judge Dewey K. Arthur in Mississippi say if anybody expressed any emotion in the courtroom, that they would be thrown in jail for contempt. It is a very common thing that judges do. So this argument does have some merit. But let's listen to see what this judge does about it, because we've known him to be very fair and down the middle, I think, throughout this trial. He's got to do this. I don't know what the judge is going to say, but he's giving it the old college try. What happened was, if you're just joining because you're watching Leilani Simon or something else, during the time when the state, during their closing, played the suitcase video, when George was in the suitcase, saying, Sarah, I can't breathe. Sarah, I can't breathe. Apparently the mother stood up, collapsed, is what Jules told us, right? Collapsed or fell to the floor. The attorney for the state stopped his argument. So I don't know. I'm not saying he knew that this was going to happen, but he stopped. The camera panned over to the family sitting in the front row, and they all walked out of the courtroom on camera. And now it turns out that we've just found out that the 2 detectives from this case were sitting with the family. Not saying that it was staged. I'm just saying that he's got an argument. It could prejudice the jury. Yeah, it could. So let's see where they go with it. It's interesting.
Responsibility to ensure that kind of thing doesn't happen, especially when they know they're going to show a video and the family of the victim is on the front row. I've never heard of such. I asked for a mistrial.
Response.
I've never heard of such a request. The victim's family has the right to be here. They were advised as to what will be used during closing arguments. I cannot make a decision for the victim's family and the homicide survivors as to whether or not they believe they can handle it.
She fainted?
She clearly, or he, I don't know, couldn't, and I believe the appropriate thing was done. They left the court.
On camera.
But again, to say this is intentional sabotage and all the accusations that continuously get made are unsubstantiated. And it does not warrant a mistrial. People get warned, and sometimes they misjudge their own emotions. I don't understand what test we are expected to run on homicide survivors. So the motion should be denied.
Motion's denied.
It was denied.
Jury's going to be back in about 13 minutes, counsel. So we'll reconvene at that point in time.
Could the state put the suitcase back in the corner?
Yeah, can we clean the well from the state's materials, please? Thank you.
He may give them a curative instruction, yeah. Yeah. Delilah says that was so wrong of the detectives to do that. I kind of like the Alberts coming in for closing testimony and closing arguments. Jen McKay, Brian Albert, Colin Albert, and Carrie Roberts. The only thing was they were not the family of the victim in that case. They were the third-party culprits, as alleged by the defense. Mama Shi, thanks for the 20. The thing that gets at me is during all interviews after suffering a trauma, no crying or emotions as if it were an actual accident. Right. Yes, I agree with you, Mama Shi. Yes. Thanks for the 20. Love you too. Love you right back. Thank you, Mary Flynn, for your super sticker. Hate Corrupt is also praying for Sir Duty Ron. If you did not hear, Duty Ron has been diagnosed with lymphoma. He did a live about it last night. And we are all praying for him. Thanks, Karen, for becoming a member. And Sarah Gray. Can't believe Phil Lash died. R.I.P. Phil. I have some phone calls to make. We're just going to go on break. I'm going to come back as soon as the court comes back on. Just going to put up the break sign so that everybody knows. And we will come back. Everybody take a break, get some water, stretch your legs, do some stretch. Take your comfort break, fill up your drink, make some popcorn. Come on back because we're going to see the closing arguments from the defense. Motion for mistrial, denied. We're back for defense closing arguments. A lot of bickering in the chat. I was watching you. Put the tie-dye on in honor of Phil Lesh. Thanks to everyone who came in and put it in. We did break the news earlier when I got a text in the family group chat about it.
We are back on the record, 2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
Dave Cacciatore on behalf of the state. William J. for Florida, State of Florida.
James Owens for Sarah Boone.
Captain Beck on behalf of Sarah Boone. Tony Henderson, Sarah Boone.
Ms. Boone is still seated at counsel's table wearing the same clothing from this morning. Are we ready to bring in our jury for the defense closing at this time? State.
Yes, Your Honor.
Defense.
Judge, I would like you to give the audience an instruction, and then if you would, instruct the state attorney to instruct whatever family members or friends of Jorge Torres may not be in here and may not be able to hear the instruction, but may come in during the trial so that we can try to get some order.
Are there any other members of Mr. Torres's family that may be outside that may be joining us? Okay, all right, so she's left, she's no longer here? Okay, that's what I just asked. Is there anyone outside? Okay.
She's outside, but she's not coming back.
Okay, all right. So, members of our gallery, good afternoon. I'm going to please ask you to please contain yourself and not to have any emotional outbursts. We had a minor one, and the person, whoever it was, had a small outburst, then hid next to another family member, and then excused herself during the last during the closing. It seemed to be minor in nature. However, I'm advising everyone that at this time, if you believe that you cannot control yourself or your emotional responses during the defense's closing argument or any rebuttal by the state, I'm going to politely ask you to excuse yourselves at this time. All right, thank you very much. Mr. Owens, anything else, sir?
No, sir.
All right, state.
We're ready.
All right, let's bring back in our panel. We'll just give them a couple minutes to do that. Thank you.
They're making their dinner. Oh, dinner selections. Oh, there's Detective Goddess Chelsea in the front row with the fam. Caught, spotted. Detective Goddess Chelsea Copsel, aka Jacqueline Smith from Charlie's Angels. Freeze game on point. The jury is making their dinner selections, so they're taking a little time. At least they're not going to just throw pizza at them like they did in Ashley Benefield's case. They've been told they can stay until 10 p.m. tonight. So I expect we'll have a verdict tonight. What say you? Oh, hi, Goldie. Look at that. Great minds. Yes, they will start deliberating today, and then not over the weekend, but they are able to stay until 10 p.m. They got a special dispensation from whoever the judge needed to get the dispensation from to stay until 10 p.m. So we'll be on verdict watch until 10 p.m. But of course, we will end this stream and then come back right away if there's a verdict. Usually the judge tells the attorneys to be within, be able to get back here within 10 minutes or something, depending on where they are. Christina, my little sister and I used to babysit for one of the Grateful Dead's traveling chefs. That is so cool. So cool. I saw so many parts of the country that I never would have seen if it wasn't for following the Grateful Dead around during all those really fun years. It was a good time. I went to college in Boulder. We were the Buffs. I'm Buffs. Go Buffs. And spent many years in Boulder. And then went to law school at DU, Denver, because I loved Boulder so much I did not want to leave. Where are my Colorado friends in the chat today? Over under poll. Well, let's do a poll for You want to wait until after he does his closing to do the poll on what we think will be the verdict? Second degree murder. We got choices: second degree murder, manslaughter. I think the third was negligent homicide, or justifiable homicide. Or straight up not guilty, because I think we only get 4 choices on the poll. Hey, Colorado. And my peeps, or Colorado. If you live there, you call it Colorado. Scope Puffs. I know. R.I.P. Phil. Oh my goodness, Kate's got it all. She's Colorado born and Massachusetts raised. Where do you live now, Kate? Are you part of the Canton crew? Fort Collins in the house. Another Colorado. We have a lot of Coloradans. Yeah, so the Buffs are playing Cincinnati tomorrow at home, and kickoff on the East Coast is 10:15 p.m. That's what they do for those primetime games now that Deion Sanders is the coach. Prime time. Love me some Deion Sanders. I think if we win this game, we're going to be bowl eligible for the first time in, I don't even know. I don't even remember how many years. All right, we're on real time, so not a whole lot we can do except hurry up and wait. Let's change the subject now for a little while, okay? All right, everybody tell me what you want to talk about. Something else. Something other than Sarah Boone. Aaron lived in Fort Carson, Colorado for 3 years. Loved it. Pull after his closing. All right. Army brat born in Colorado, Fort Carson. Look at this, Glenwood Springs. A lot of my Colorado friends in the chat. We should have a reunion. I'm coming out there to go to a game. Maybe we should get together. Do a little meet and greet. Let's see. I wish there was a sentence for permanent mental health care. I wish there was too, but I don't think that she qualifies for that. I mean, that would have been nice in the Carly Gregg case, but I don't know about her. Chelsea's, I'm ready to see her cuffed and gone. Cuffed and gone. And look at Linda's in Colorado too. Your kids were born in Massachusetts. Here's some West Newburyport, Massachusetts right here. New Jersey, Stella. Look at Longmont in the house. Longmont's even in the house. Oh, thanks for going shopping at my store, Radine. Sco Bubs. I know Radine's right in Boulder. I'm coming. We coming. Looks like they're frozen, but they're not. But their sound's not up, so we're not here. Please do not use the F word in the chat. We call it duck here. We even have a rubber duck emoji. Fans, see, here's the thing about YouTube. Here's the thing. They scan the chat. Actually, we were demonetized for the Sarah Boone stream the day that she testified has been shadow banned as not friendly to advertisers. The day that Sarah took the stand in the afternoon, that entire stream. I wonder if other people, I reviewed it, but I mean, it's under review, but who knows? There may have been some words that she said that they didn't like. The YouTube police are real. They are real. Long Island. Liz F is from Long Island. Dion is the man. Dion. Jersey girl recently replanted to North Carolina. How are you handling this switch there, Courtney? Do you like it down there? Different? People different? Not as fast paced? Curious. Connecticut born and Florida raised. Don't these people know I need to get a pizza? And you need to get what for the World Series tonight? I can't see what that emoji is. You can go, Sarah. Sarah, we're good. Sarah, we're good. Sarah, we rooting for the Yankees, Sarah? Sarah, we rooting for the Yankees? Mm-mm. Thought you said Collins in the house. With only 6 people, yeah, I think they will be back. What's my Halloween? I don't do Halloween. I don't do Halloween. I just never was a big fan of Halloween. Then you get invited to a Halloween party and it's like, wait a second. So I have to actually get up, get ready, and go somewhere. Now I gotta find a costume too. It's so much pressure. It's so much pressure. Favorite Halloween candy. Okay, that I can get on board with. I mean, I love a Heath bar. I gotta say I love a Heath bar. And I also love Almond Joy. I'm a big coconut fan. People either love it or hate it. Coconut.
I was just, I don't know if that is allowed by the court or.
Anything?
Been allowed since I started practicing in 1997.
If you want to split up your closing between the two of y'all, that's fine by me.
Well, I intended on doing the closing, but when I finish, Mr. Henderson wants to say something. I may ask you to.
I've never seen it done that way. I've understood the sandwich can be broken. I've never, ever seen a single closing argument split by another attorney.
Sandwich. We've seen it. We've seen it in Florida too. Didn't we see it in Carly Gregg? Didn't we see it in? That's Mississippi. I don't know. To say that he's never ever seen it before, like really, what does it matter, dude? You're winning. You're gonna get a big W at the end of this, prosecutor. So, like, really, do you care?
If it's a discretionary issue, I'll leave it up to you, sir, on what you want to do and how you want to present your closing.
I mean, whatevs. I know that's the thing. It pulls out your fillings and stuff, the Heath bar, I know. Happy birthday, Janine. Happy Halloween birthday. Seize the day. It's okay. I'll allow it. It's going to be the most expensive World Series tickets in history between LA and New York and all the celebrities and all the corporations and all the corporate people that are going to buy boxes. Like the cheapest seats. Let's see what the cheapest seats for tonight's game are.
Who would be objecting during rebuttal?
Mr. Owens.
Okay, there you go.
Oh, this typing, all of these little noises in my ears are bothering me. Okay, so tonight for the World Series Game 1, which is tonight at Yankee Stadium at 8 p.m. in the Bronx, the cheapest seats are $1,081 each, and those are nosebleeds in the outfield in the grandstands. No more $5 tickets like they used to have in the bleachers of the grandstands back in the day of show. And look, with fees on StubHub, $1,462 each. Okay, that's more than decent seats to Taylor Swift. I'm just saying. And for that price, I'd just rather watch it at home on TV. I'm just saying. Yes. Cheaper go to the Yankees than go see Dave Matthews at the Garden? No way. $1,600. You're overpaying if your tickets are more than $1,462. I got my tickets through Warehouse, and it was they were face. For two Yankee tickets, you could go to Cancun and see Dave Matthews for 3 nights, all inclusive, food, booze, all in. 3 concerts on the beach for 2 tickets of 1 World Series game. That's crazy, right? And you don't have to wear pants when you watch it at home. Thank you, Erin. You understand what I'm talking about. I know there's probably a lot of Red Sox fans. Yeah, including fee and taxes, right? $1,462. I mean, that's grandstand seats all the way in the back in the outfield. All right, here they come. All right, my sound is up. Their sound is not. So he's going to get 90 minutes. It's 4:45. So he's got until 6:15. And cheapest tickets to Taylor Swift cost more than $1,400. Yeah, Cancun is rocks. I know, isn't that ridiculous? How can you even take your kids to a baseball game anymore or a hockey game? Yeah. It's $20 for like a big beer in a can. Just came in. Closing arguments are going to be starting for the defense. They have 90 minutes. Jury's allowed to stay tonight and deliberate until 10 p.m. and then they come back on Monday if they don't reach a verdict. Okay, Lance.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? Thank you. Y'all may
Hot
be seated.
tip on horses for the Breeders'
Sure,
Cup.
for one of the last times, if you could, please raise your hands to confirm that you complied with the court's instructions. All hands have been raised. Members of the jury, at this time, the defense is going to proceed with their closing argument, similar to the state's closing argument. These are not evidence. These are just arguments, and I ask you to pay attention to them. Thank you. Mr. Owens, you may proceed, sir. Yes, sir. Thank you.
Ladies and gentlemen, good afternoon. Y'all know me, I'm James Owens, along with Tony Henderson and the girls. We're all from Milton. I think y'all figured that out, that we were from out of town. Santa Rosa County, it's northwest Florida, close to Pensacola. And my buddy Kevin Beck, he's a longtime friend, he's from New Mexico. The defense team, is here, and we're here to represent Miss Sarah Bennett. And we feel confident that we're going to be able to show you why she's not there. Okay? And I'm going to take my time. I've got some notes. I'm not the most organized person in the world. I've got some exhibits that we're going to show you. And then we got a couple of videos at the end. Okay? And we'll try our best to help you make the right decision. Okay? But yeah, Milton's a small town.
Objection. Problems.
Overruled.
See how small it is.
It's in poor form to object during the closing. I mean, really, within the first minute of his closing, you're going to object because he said they were from Milton because of relevance? Like, come on. Don't be a dick.
7 miles away is another small town called Pace. In between that is a Walmart. Very small town. We didn't know what to expect coming down here to Orlando.
Relevance.
Judge, I'm allowed to.
I'll give you a little bit more for intro, but then we need to get into it.
I'm going to get into it. I wanted to say, it's a small town, good people. We've been down here 3 weeks. We didn't know what to expect. We've been surprised. From
Objection. Improper argument.
Mr. Owens, approach.
Yeah, Mr. Owens, really? You've objected for like 4 times in the first 2 minutes of his closing? He's trying to tell the jury that it's a nice place where they live.
It's just, since we've been here, we've been treated with respect and hospitality, and just like we've been at home. We appreciate that. Now, I'm going to do some reading, and then I'm going to do some talking. But ultimately, this is about justifiable use of force. That is a legal defense in Florida. We as citizens, the law is designed to protect us from defending ourselves, to protect us from potential attack. And you are the only ones, in this case, because Sarah Bennett was arrested, that's going to be able to look at it critically and objectively. Not like the state attorney.
Objection. Improper argument.
Overruled.
Objectively. And the law in Florida gives y'all the power and authority to do that. The state attorney can't make the decision. They can't make the decision. They can try to influence you. And we're going to talk about some of the things they did here in this trial. And some of the things they said.
Objection. There was a motion.
Yes.
I don't think this is going to go over well with the jury. All of these, right? I mean, let him talk. You're winning. You're going to win. She's going to be convicted of something. Just like let him speak. Let him defend his client. I mean, it's enough already. We're on real time, so there's nothing we can do about it. And I guess he's the one doing the rebuttal, so he's the one who's doing the objecting, but it's just in poor form. What the duck is going on, Kimberly? Mr. Owens is trying to do his closing, and it's going to be 90 minutes, and in the first 5 minutes, we've had 5 objections and 2 sidebars. Sidebars. Yeah, it makes them look desperate. Like you're winning. Be confident in your case. It's enough. It's a bad look. Yeah, the jury's going to be like, come on, let the guy speak. He's trying. Yeah, they do that sometimes to throw off somebody's flow. Sometimes. Good point, Courtney. Thank you, Stella Bella, for becoming a new member. Thank you, Jules, for the deuce and the depth you heard. They split it up, I believe. You mean the closing? It's done often. I don't know why that attorney has never seen it done.
You may proceed. Objections overruled.
Thank you, Judge. They got their side, their position, we've got our side. So we're going to talk about that. But, and we're going to talk about justifiable use of deadly force and non-deadly force. But either way, however you rule, it still justifies her behavior. And the result is not good. Now, I don't believe there's anybody.
Objection. Proper argument.
Overruled.
Objection. Reproach.
Yes.
Did you see what he just did? He looked up to the Lord and he was going to pray. All he said was, I don't believe there's anyone.
I don't believe there's anybody.
Objection.
I don't believe there's anybody. And then he says objection.
Proper argument.
And he's going to look to the Lord.
Overruled.
Objection. Reproach.
Yes.
Come on, man. Somebody asked if it's usual to give the jury instructions before closings. Depends on the jurisdiction, and sometimes they do give it before closings. And I like when they do, because then the lawyers can talk about the jury instructions in their closing, and it's ringing a bell now with the jury. Sanction him, muzzle him.
I think you will find from considering the evidence in this case that there is no doubt that Sarah Boone is a victim. That Sarah Boone has been traumatized. That Sarah Boone is still traumatized. And the reason for the trauma is Jorge Torres. The reason for the trauma is Jorge Torres. From the positive things about the man that we've seen on video, to the positive things Sarah Boone has testified about, to the violent monster he becomes. And I mean monster, because it was repeatedly. And what happens the next day? I was drunk. I don't remember. That's the gaslighting. That this young woman, vulnerable woman with nobody, just starving for love, starving for attention, and seeing the good in the man. And it was good. But every day was on the balance. She measured every day, depending on how it started and then how it ended. And that's the way she had to live her life. Day in and day out. Day in and day out. Dr. Harper and Dr. Brandon talked about trauma. Dr. Harper spoke of the veterans that she had treated for post-traumatic stress disorder. I don't know if you remember her testimony, but she spoke about some of the veterans that had been in the war in Iraq, you know, and people in war a lot of times get post-traumatic stress. It used to be called shell shock and other things. But people in wartime, or police officers will get post-traumatic stress. And a lot of them come in, the males come in with this bravado, I'm all right. I'm all right. And so that's what Dr. Harper was talking about, the veterans, that's what they'll do. But you got to spend time with them. It just can't be one session. And you've got to run post-traumatic stress testing, which tells whether they really have post-traumatic stress. And we all probably have experienced some trauma. All of us have lost some loved ones. And it's awful. You're in shock. You can't believe it. It's disbelief. You don't sleep for days. And eventually, you have to go back to work. You take a week off. Life has to go on. Life has to go on. You go back to work. Kids are in school. You get a little time, right? Time heals, right? These veterans that come back from a deployment, they get back, they get some semblance of normalcy. They may or may not get some treatment, but time helps. Time heals. Everybody, it helps. Just time. Overcoming a divorce, overcoming a death, whatever trauma. Sarah Boone had no break. No break. Learned helplessness. Just giving up. Just giving up. I can't get out of this situation. They broke up. She'd go about 2 days. Texting and calling. Just learned helplessness. And it's, in the manual. Battered Spouse Syndrome is not, but what did you hear Dr. Harper say? She suffers from post-traumatic stress. That is a mental disorder. You are actually undergoing the psychological effects of post-traumatic stress. You're not in your right mind, and it's repeating itself. It's repeating itself again and again, day in and day out. And when you look at this law, that's what you have to apply. Someone in Sarah Boone's shoes, when you're deciding whether her conduct was reasonable. Got a bunch of notes. It was something I wanted to read. with a plea.
Oh, boy. You're burning the clock, Owens.
Sarah Boone's long-term exposure to abuse created a state of learned helplessness and diminished her capacity to assess risk, especially in moments of heightened stress. The cyclical nature of this violence, the tension building, the battering, the contrition phases, caused Sarah to be trapped psychologically in that relationship. Due to this clear abuse, Sarah Boone had a reasonable belief of imminent harm under her state of mind. Jorge Torres had a history of violence against Sarah, and as a result, Sarah Boone's actions were the result of fear conditioned by abuse she endured over time. The cumulative effects of long-term abuse, as we saw her behavior on the 2-minute suitcase video, is a trauma response. Sarah Boone acted out of a sense of preservation. While tragic, it was not driven by malice, but a mind ravaged by abuse. And I'm going to ask you to try to understand. Try to understand. Sarah Boone being emotionally and psychologically broken, whose actions may have been misguided attempts at survival but not murder. Imminent danger, her response reacted to that belief. It's somebody suffering from the long-term psychological effects of domestic violence. Who spent a lot of time? Dr. Brandon, you remember him. He was the first expert on trauma. Took some notes. Kevin Beck, you remember, did the direct examination of Dr. Brandon. He was from down in Miami, I think. He talked about the trauma that you cannot escape from the abuse, so you develop coping skills to protect yourself, knowing that the bad things will happen to you. It changes your behavior, not only your behavior, but your thinking. Your subjective thinking about fear and what to do. And if you remember, Dr. Brandon said it's all about that person's perception. Okay? A lot of times they will self-medicate with alcohol or drugs. A lot of times they suffer from anxiety. Basically, he said the trauma ends up being terror because you do not know what to expect. You do not know what is going to happen that night. It may be a great night. You may drink, and both of you have a great time. He falls asleep, passes out, you fall asleep, passes out. But it may turn, by depending on his mood. I don't know if you can tell, she would try to placate him. Dr. Brandon said, you know, when you're trying to evaluate somebody, it takes time to get them to trust you. And the ultimate goal, he said, is to be a behavioral detective. If you're a forensic psychologist, is to be a behavioral detective. And the ultimate goal is to put yourself in the abused person's eyes so you can better understand their world. But ultimately, it's their perception of danger. Their perception of danger is what you have to look at. What a reasonable person would do under their perception of danger. Now, I want to go on. Trauma experts explain how victims' reactions in moments of stress are the product of the damaged psyche. Her actions, although tragic, and it was a tragedy, Jorge Torres lost his life in that suitcase. It's a reactionary response to sustained trauma. It's as if Sarah was acting out of a deeply ingrained fear and helplessness developed over the years. So it's a different desperate need for survival, but battered women do things to keep the peace from time to time. And when they feel like they have a small portion of momentary power, they may enjoy that by vocalizing their position to the abuser. Sarah Boone's not perfect. Sarah Boone would argue with him, talk down to him. Some would say was somewhat abusive to him. Sarah's not charged with that. Sarah Boone is not charged with that. And I want to read you something on that subject. Essentially, okay, I don't know where it's at, but I'm going to have to come back to it. But essentially what it said was, eventually it's been a 2-week trial. I've got a bunch of notes. I'm trying to get this right. I know it's important. What I wanted to say was someone can be mean and angry and hateful, intoxicated, and still be abused. They're not mutually exclusive. And mutual abuse exists where one is abusive towards another. And eventually the victim, Sarah Boone, trying to fight back against the abuse, became verbally abusive. While the victim has committed verbal abuse, it is important to remember that they, Sarah Boone, are the victim and have been pulled into an extremely vicious cycle where they are trying to survive. Sarah Boone intentionally left Jorge Torres in the suitcase. What's the act of a battered spouse syndrome woman? She went up to her room, she fell asleep, and passed out. These actions are disconnected.
Well, I mean, passed out is the first thing I'm going for. Is closing that tagger. She went upstairs, she passed out. Yeah, okay. Now we're getting somewhere.
Ultimately, she didn't let him out because of her fear that she knew if he got out in that moment, what he would do. That's real fear. That's real trauma that she was experiencing at that time. Now, I talked to you about force being used, and I think I talked to you about blocking an attack using a physical restraint like the suitcase to block somebody's attack. And the example I give, I got a couple of examples that may or may not apply. Let's say you're in a bar and you got your buddies and the other guy's got their buddies and they're drinking and it ends up being an argument between two of them. And you realize that these two are fixing to get in it. Well, one of your buddies comes around on the other side and grabs the guy before he's able to strike him, right? So you're committing an offense on this guy, but it's a restraint. It's a restraint. Are you grabbing?
Just brings me back to the waterfall and those guys playing grab ass, Higgins and Brian Albert, the way they grabbed each other and they did the whole thing.
On the net and try to get him out the bar. So yeah, you're committing an act, but it's designed to defend another, which is legal. Or let's say you have a situation where you have a police officer and he's on patrol. You know, he's in uniform, he's wearing a firearm, and of course he's got the a bulletproof vest. And he goes to a call where there's a suspect that may be armed. A suspect that may be armed. And so he gets there, he gets out of the squad car, he's walking around, of course, he's taking out his gun because he realizes he may be armed. And eventually he sees the suspect, and the suspect reaches for his waist. Now, in that moment in time, that officer has to make a decision. Am I going home with my family tonight?
Compass mentis?
And I asked Dr. Werner about this Vaseline thing he's called.
What? Wait, stop.
Fear.
Wait, is that who got kicked out? Something is so funny. Auntie Bev, Susan Constantine, the body language expert who was really mean to my friend Will the Glare, is the one who got kicked out of the courtroom. Was she the one with the cell phone? Oh, I was distracted by Phil Lesch's passing. I didn't even know about this. No, because now I'm going to laugh with you. This is a very weak closing, I got to be honest. I thought he was doing a great job until now.
Response or fight or flight. You know, those decisions are made, it's instinctive based on your set of circumstances. She instinctively reacted to her unique set of circumstances to save her life or save herself from another one of these. I'm 63. I can't imagine that. I can't imagine that.
It's not just you.
Her father's not around. I need to talk about the case a little bit. And if you remember, I'll get back to it. If you'll remember,
He's putting me to sleep too. I'm like lollygagging. What did I say? That was funny.
Let's start with the witnesses, and then I'll talk about the second. But the first witness out of the box for the state, if you remember, was Juan Torres, the brother. Remember that? It was some time ago. I know it's been a while. Y'all taking notes. You may have to go back. Their first witness was a good witness for us. Their first witness in their prosecution of Sarah Boone for murder was a good witness for us. Remember Tony Henderson?
Not even 30 minutes.
Juan Torres. Asked him, what did you hear Sarah Boone say? Juan Torres, she was yelling, he's been choking me. He's been choking me.
Doesn't mean it's true.
Mr. Henderson said, did that surprise you?
He said no.
Juan Torres said no. That family knew what was going on. The police knew what was going on. The neighbors knew what was going on. Pearl Walker came in here, 80-something years old, no wheelchair. Kevin Beck called her up. She saw it. Is there any doubt? Is there any doubt I tell you why there's no doubt. In cross-examination, I got Dr. Warner to even admit. Did you hear it? Yes? Okay, Mr. Owens. She suffers from Battered Spouse Syndrome. Wouldn't admit it on direct. Well, maybe I don't really know. I hadn't had enough time to really see her.
We call that a pregnant pause, Mike.
You hadn't seen the pictures? You hadn't seen the 2-minute video? You've seen her one time earlier this month. One time. And she's going to start testifying about stuff she's never said before until she showed up in court. About, well, based on what she told me, I don't think she was in imminent fear. Come on. This is a courtroom. This is courtroom. Good thing y'all are here. We thank you. But it gets even worse than that. It gets even worse than that here in this courtroom. The state attorney referred to these pictures. And I was going to rise up and
Overruled.
show these pictures to you.
Overruled. You may proceed.
And I was going to rise up and show these pictures to you. Well, yeah, I'm going to do that. They put her on trial for murder. But what did they say? And I got to turn to this. Make sure I get this exactly like they said it. I took a bunch of notes. Let me make sure I got this quote. Can't even find it. It's something to the effect, maybe Jorge Torres is the battered spouse. Can you believe it? Can you believe that? Now you know why we're here. Now you know why we're here. Little boys learn early on that girls are different. You do not put your hands on a girl. You can't wrestle with them. You can't punch them. You can't kick them. You can't treat women that way. When you become adults, I don't care what she does to you.
I wish she did.
I don't care what she says to you. If she gets in your face, whatever she does, you do not have a right to hit a woman. No, sir. What has the state attorney tried to do?
Objection, proper argument.
Sustained.
What has they done?
Objection.
What evidence have they tried to put on?
Overruled.
What evidence have they tried to paint Sarah as? What evidence? Controlled and manipulated were the words they used. You know, this ain't the 1900s. This is 2024. What's all these text messages? Why is that relevant? What are they trying to claim? She provoked his violence? She provoked his violence. Isn't that what they've done here in this trial?
Proper argument.
Sustained.
Let me get back on this.
Right.
Abraham Marino. I don't know if you remember him. Abraham Marino changed his statement. They took a statement from Abraham Marino in which Sarah stated, I don't know if you remember, but it was when the police were all there. I think they got the tape out and some neighbors were coming around, and there were 2 or 3 neighbors sitting around. He said Sarah came out and stated it was an accident. Okay? Well, then, it was an accident. And this, Abraham Marino knew Jorge Torres from Philly. Okay? They were friends. They would talk either at the complex, or if Marino went to Hall's Ace Hardware or Ace Hardware, what it's called. The state attorney notifies.
Judge, I'm going to object to reading from things that are not in evidence.
Approach.
Yeah, you can't do that. You can't read from things that are not in evidence. It's just not allowed. It's just not allowed. This is not going as well as he had hoped, I don't think. A little rating on that. This is pretty cool. Oops. The Empire State Building tweeted, tonight from 9 to 10 p.m. we will shine in tie-dye to honor the life and legacy of Phil Lesh. That's pretty cool. Pretty cool. Many a Grateful Dead show at the Madison Square Garden. It's okay, we didn't miss anything. Yeah, you don't hit a woman, and you definitely don't leave someone in a suitcase to expire. So there's that. Elizabeth's like, well, wow, he sure did. Wow, he sure is proving he's from a small town. She didn't catch a break with him. Everyone's nodding off. We're all nodding off. You guys having trouble staying awake? We're not even into we're like a half an hour into this. And he's got another hour to go. Split between him and his co-counsel. He's trying to be like Ben Matlock, but coming across like Barney Fife. Says, hey, do you need pizza, duck? Hey, do you need pizza, duck? Yeah, apparently that was Susan Constantine's phone that went off in the courtroom when he said, get out, you get out. That was her. The body language expert who's there with, I guess she's there with STS, Surviving the Survivor, right? She's been guesting with him like all week. I don't know if they've been doing shows together. Scott just walked to Montauk Point and back. Did laundry and he's still going. Yeah. Still going. For the love of the traveling Mary. Hi, Sarah. Thanks for the 5. Listening to Ripple, and I'm deeply grateful for you bringing us all here to watch with you on this sad day. Thank you. Thank you. Chantal, thanks to all the mods who were so patient with Chantal's technical errors today. Thank you so much. YouTube has been glitchy for a lot of people. Remember that YouTube is owned by Google and it's attached to your Google account. So Sometimes you got to refresh your browser. Sometimes you got to do all kinds of stuff and things. Like it'll sign you out of YouTube. I know that whenever that happens, because I know when that happens because I get a commercial when I'm watching YouTube and I pay for premium. So Kiki, just want to thank this wonderful chat and the best mods. Of course, Mel, without her, we wouldn't be here. I'm losing brain cells with this closing. Me too. Losing brain cells with all of these delays. And I just want to take a nap. It's nap time. I need to be in bed now. Margaret's only staying awake because she's preparing supper. Supper. Oh, goody. More computers on camera. Right. They were told not to do that. They were told not to do that. Yeah, Susan Constantine is a body language expert. That was on the Glares show one time, and I think she was not very nice to him.
You may
What I
proceed.
heard.
So for 4.5 years,
Word on the street.
Marino says, all I heard Sarah say that afternoon was it was an accident. Then he came in here today, or this week, and said, no, she said I was teaching him a lesson, things got out of hand, and then I fell asleep. 4.5 years later, we know he's friends with Torres. We heard it here. Now, I want to talk to you about the two boys that live right next door. You remember Vincent Battaglia and Brandon Motes? Remember those guys?
Yeah,
And
the
remember,
college
it came out
students.
in testimony, this event happened on February 23rd of 2020. But it came out in the testimony that Sarah had said, Jorge Torres, the night before, February 22nd of 2020, grabbed me by my hair and pulled me down the stairs in my apartment from top to bottom, which is consistent with what they were saying happened, remember? But they got their dates wrong. And remember, Mr. Henderson called Deputy Copsel or Detective Copsel up in our case, and she had to say, yeah, I didn't take their two statements until the 27th, February the 27th, remember? So they're remembering back, and they both had similar stories. Of course, they had time to talk by then, the 27th. I think the only recorded interviews they got that the night of this event, February 23rd, was from Sarah Boone and her ex-husband, Brian Boone, right? So they came back following up on the 27th. That's when they got a statement from Brandon Motes and Vincent Battaglia. And at that time, they said, yeah, we heard that sound. You remember Sarah testifying? No, that was the night before. I complained about that, and I think one of them had testified. Yes, she had said something about being drugged down the night before. It may have been, I can't remember now who it was, one of them. And, it looked like that there may be some implication that Sarah got him in the suitcase and pushed him down the stairs. But I think we didn't have anything more of that. Remember? And then this photograph, which we introduced, which shows the bottom of the stairs. As you can see, there's Lucas's bookshelf right here. This is where Sarah Boone stored Lucas's stuff. And you can see it's not disturbed at all.
Thank you, Radine, for the super chat. Super chat.
Anyway, I want to get back to Sarah. I want to talk a little bit about that. But let me talk a little bit about the law. Unjustifiable use of force is legal and lawful if you reasonably believe, I think we all probably all already understand it by now, you reasonably believe it was necessary to prevent imminent threat to harm. The law is crucial, ensuring that individuals can safeguard themselves in potentially dangerous situations. By acknowledging you have a right to defend yourself when you have a reasonable belief that force is necessary to prevent an attack. Okay? What did Mr. Henderson say in jury selection? You don't have to wait. You do not have to wait. if you're facing, in your mind, a reasonable, imminent threat, you don't have to wait. Let's talk about Sarah Boone and this unconventional form of physical restraint to block the attack of Jorge Torres. What did she say? Salt tape. Now, you got to think about that. You got to think about what was going on. You got to think about the trauma she was undergoing. You got to think about they've both been drinking. And you got to think about the fact that it was all fun and games for a while. And I think the biggest thing to know is that Jorge Torres chose to get in the suitcase. He's a grown man. That was his choice.
He also begged to be let out.
To get into that suitcase. He voluntarily got into that suitcase because they were drunk and being silly and stupid and playing hide and seek. Which I guess when you get so drunk, that seemed like a good thing. Zipped him up, they're laughing, carrying on. And as you know, Sarah likes to videotape a lot. And I know you've seen some of these videos and you're wondering why, but I think the evidence shows that when George is being videotaped, he's not going to do anything. If you think about that, when George is being videotaped, that's like her power. You know, Dr. Harper said that Sarah's words are her power. Sarah's words are her power. Physically, she's no match for George. Physically, she's no match. But that's her power, is her words. When she gets a chance, to have some control, that's what she does. And she videotapes because she knows when she's videotaping, she can tell it like it is. I can tell him what I want to tell him. A couple of these videos you've seen, she's telling him like it is. But she's got that video camera on, and George knows. He's being videoed. We've got one that we're going to show you a little bit. Before he loses it. Just a little bit. Right again.
I think we're going to need a couple of magnums of Woodbridge to get through this. What say you?
We got the TV. But they're kidding around, playing around. Then, Sarah realizes, okay, this is my chance to say something to him. So she sits down, she turns on the phone, and you've seen the tape. You've seen the tape. For everything you've done to me, are the first words out of Sarah's mouth when the video begins. There's a lot packed into those words. Think about that. For everything you've done to me.
So he deserved it? This is not going to land, dude. How about she was an alcoholic and she got drunk and it was an accident and she went up and she passed out.
That's in direct
Forgot he was in there. Forgot she taped him. That would have been such a much better defense, don't you think?
As a result of the abuse that she suffered at the hands of George Torres. She wants him, for that moment, to feel how she feels. She wants, for that moment, to feel, for him to feel how she feels. How uncomfortable, lack of control that she feels when George is violent with her. Just for a moment, she won't do it to him. And if you can imagine,
Approach.
I'm
she was crazy.
really fighting it.
I think from the evidence, you can determine she was crazy. She was crazy about that. And I don't know if, of course, it's a syndrome, but she felt like she couldn't do without it. And let's say she videotapes it, and then it's turned off. And there's a 9-minute gap, 11-minute gap, whatever it is. I said 11, they're saying 9. I think if you count 2 of the others, it's 9. But there's 9 minutes that we don't have video. But what did Sarah say? Now, if you remember when you listen on that video, George is talking in a normal voice. He's not stressed. Of course, if you're talking, you can breathe. She had said she had some air. And of course, she doesn't realize the situation, that it's going to end the way it ends. So she has no appreciation of that. It's a canvas. All she knows is an old canvas suitcase that she's got some, the 2 zippers removed or spread out a little bit so she thinks he's not being serious. But eventually he gets angry. She gets angry, he gets angry. He says words to her, and then his hand starts to come out of the suitcase. She also said his tone changed. And I know everybody's got a cadence with their spouse or boyfriend, girlfriend, but you know what I'm talking about. We've got a way of talking to people. We've got a way, your wife, your husband, you know each other. You know when they come in from work, what kind of mood they're in. Just by a couple of things, the way you can just sense it, right? Well, especially somebody as hypervigilant as Sarah and as hypervigilant as a battered spouse woman would realize that he can flip the switch at any time. When I get out of here, I'm going to end you. And he realizes he's getting out. He got his hand out. At that moment in time,
That would have been a good
in Sarah's
time to
mind,
tape.
That's an imminent threat. So she's got a justifiable right to use force. What did she do? She went over there and grabbed it. She lifted it up. She tried to get his hand back in, remember? She tried to get his hand to go back in. Wouldn't go back in, so her son's back was 3 feet away. Where the police found it the next morning. Same spot. No attempts to hide. No attempts to delete phone. No attempts to tamper with evidence.
She was
nothing.
hammered. She didn't know she took the videos,
In the
dude.
same spot as it was. She picks up the bat. She pokes. She pokes him hard, trying to get him to stop trying to get out. And eventually he does. And you've seen the blunt force injuries, and you saw some of the circular injuries where you can tell there's a poking. I think it's right around here. And she poked him several times. You remember the pathologist said, I think, maybe 5, 6, or 7 times. She pokes him. And he's got some scratches. I don't know if they'll let you look at it, but on the back of that suitcase, it's got some bars, some metal bars that are inside the lining. There's some lining, and it's for support when you walk in it. She testified. You heard what she said, that she was justified. That's uncontroverted testimony. Now, let's talk about the jury instructions just for a minute. And I want to talk about reasonable doubt for a minute. Can't find the page, but I've got one.
All right, 90 minutes is way too long for closing in a case like this. It only took 5 days to try this case. Why do we have to sit through an hour and a half of closings? It's too much.
Let me find it. If y'all all looking. think it's on page 15 of 22. But we're going to talk about reasonable doubt in a minute, but if you look at those bottom three short paragraphs, it is the evidence introduced in this trial and it alone that you're to look for the evidence or look for that fruit. A reasonable doubt as to the guilt
Look for the fruit.
may arise from the evidence itself, a conflict in the evidence, or lack of evidence. But here's the main thing. And, obviously, I represent her. And I'm trying my best to show you honestly and fairly the doubt in this case. And 5 reasonable doubts, 17 reasonable doubts, 25 reasonable doubts. You have to have 1 reasonable doubt. I'm trying to show you throughout the evidence that each one of you can have a different reasonable doubt. Difference, but 1 reasonable doubt about the state's case, and your verdict is not guilty, according to law. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, speculative doubt, or imaginary or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. And this is a deeply held belief. Reasonable doubt is the highest standard we recognize in litigation. Car wreck or something like that is preponderance of the evidence standard, 51%. You're entitled. Abiding conviction, that's a deeply held belief that you must have if you're thinking about something. That's a firm belief. That's a level of certainty that you would have. That's what you got to have as a juror. I've got to be certain of her guilt. If, on the other hand, if after carefully considering, comparing, and weighing all the evidence, which we want you to do, there is not an abiding conviction of guilt. So I'm not certain. I'm not certain of her guilt. Or if you have a conviction, I think there's some evidence of guilt, but it is one that is not stable, one which wavers and vacillates. One which wavers and vacillates. Then the charge is not proved beyond a reasonable doubt, and you should find the defendant not guilty because the doubt is reasonable. You understand that? You've got to be certain of guilt. That's the high standard we recognize. If I've got some evidence of guilt, so okay, there's some evidence for conviction, but it's not stable. It wavers and vacillates. Then under our system, you've got a reasonable doubt. And you've got the power and authority and the obligation under the law, if that's the way you feel, to vote that way. Later in the instruction, it goes on. It's up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You may rely on your own conclusion about the credibility of a witness. That is totally the province of the jurors to decide. A juror may believe or disbelieve any or all the part of the evidence or the testimony of any witness. I want to show you this before I forget it. But Dr. Werner said, this is their expert again. He testified that Sarah Boone suffers from Battered Spouse Syndrome. Battered women's experiences affect her perception of imminent danger. Those past experiences with Jorge Torres, and there's a bunch, affect their perception. Remember, Dr. Brandon,
I put the poll up.
Dr. Brandon talked about perception of imminent danger. Victims of repeat violence may fear death in situations others would not. The reason Sarah experiences all this, the reason she was feeling the way she was feeling, that imminent threat of danger from Jorge, was because of Jorge Torres. Jorge Torres is responsible for her mental state because of the way he has violently treated her. She reacted to his attempts to get out because of the way he treated her and the way she knows what is he going to do if he gets out of the suitcase? She knows. The second video is played. She's flipped it back upside right. You hear him, it's 22 seconds. He says, Sarah, she's not going to open that suitcase. She's not going to open that suitcase. He's already threatened her. She used the bat to get him to stop trying to get out of it. Why would she do that? Why would she do that? I know what he's going to do. I know what he's going to do to me. I know him like I know more. I know him more than he knows himself. I know what he's going to do to me. You don't have to wait. That was justifiable. Now, you got to understand this. She intentionally used the bat to defend herself. She intentionally didn't unzip it to defend herself. Both of those are lawful under our law. She went upstairs. The dogs were upstairs. At some point, she called her husband, her ex-husband, Brian Boone. We know that many times she testified, or somebody in court said she would often flee to her ex-husband's house sometimes. I believe that testimony came out from either Sarah or somebody. That sometimes she would flee, or sometimes she would flee to upstairs. One of those two. But the dogs were up there. She made a phone call. At some point, she fell asleep, passed out, fell asleep. We don't know. They had 2 big bottles of wine. Right? That was unintentional. That was unintentional. His death was unintentional. You remember when she was in the interrogation room? Do you remember that? Now, I don't know if we did a good job of this, but it came out that she got arrested. You remember the one time when she got the black eye? She got arrested for strangulation. And
I don't know if we did a good job of this. Did he just say that? Okay.
you remember that? They ended up over there by the dryer, and he was banging her back of her head on the floor that had very little carpet on it. And she ended up getting her arms out, and then she grabbed his neck. And she eventually got him off of her. And that's when he got up and stomped her in the eye. Remember? Well, the police came for that event, and they took statement, and Sarah was honest with the officers about what all, and they arrested her. You remember? Remember that? They arrested her. And she said, why? I was fighting back. You remember that? Why? I was fighting back. So from that point on, she didn't trust law enforcement. The video that they showed a while ago about George, that was about dropping the case, where she was defending herself and fighting back. I want to talk about this investigation by law enforcement. Now, she didn't know the law. She's not a lawyer. She gets up the next morning. Brian's calling. Sarah's got to pick up Lucas at 3. Brian's calling. Eventually she walks down. She's looking for George. Where's George? He's quiet down there. Then she looks in the bathroom. She looks out. He's smoking a cigarette. He's on the computer. She sees the suitcase. And you can imagine.
Objection, golden rule.
Sustained.
She sees him in a suitcase. She panics. What does she do? What does she do? She tries to get her fiance out of the suitcase. They're engaged to be married. She's not trying to kill him. They're engaged to be married. She gets him out. She tries to do, he's purple. She tries her best to do CPR. She doesn't, and you heard her, I didn't know what to do. I didn't know, call Brian. That's her safety valve. That's all she's got.
It's her enabler.
Brian eventually says, just come over. She calls again in 2 minutes. I'm on the way. He gets there. You got to call 911. Man told her before, call 911. She calls 911. She tries to do CPR again. Is she busy trying to hide evidence? She busy trying to hide evidence? She busy trying to hide the back? No, she's trying to save his life. If she can.
I don't think she did CPR. Do you?
So the police get there. She knows
I don't even think she knew how.
if she told them, she fought back, she's going to be arrested. That's what happened before. What happened before? Like George said on the video, she'd never been arrested before. Before that time, she was charged with that with George. She lies. She lies. She's scared. She's scared. She doesn't know what to do. So she lies. She makes a decision to lie. Don't trust law enforcement. She doesn't know the law. She doesn't call a lawyer. She talked to Officer Rodriguez, who was the first short black female that came up here first, the first one that arrived with body cam. Talks to her. There's a recorded statement there where she doesn't tell the whole story. She lies. And then the detectives eventually get there and get her in the squad car. You hear the audio. I think it was played. She lies again. Then the next day, she goes down to the sheriff's department. Now, if they would have told her, hey, man, we're going to arrest you. And she gets a lawyer to go down there to make a statement. And the lawyer would advise her.
Objection, facts on evidence.
Sustained.
Move to strike.
Fair.
Stricken. The jury will pay no mention or give any weight to that statement.
Don't talk about a lawyer.
She didn't have a lawyer present when she made those statements.
Right. She didn't ask for one either. She's so
She didn't
smart.
know she was justified
She excelled at everything.
in defending herself the way she did in this dysfunctional, toxic, abusive relationship. I don't know if you remember, it was a 2-hour video, but there was some things she said, it was not intentional. And eventually, she wanted the detective, it was Detective Lowen, the male detective. And she said, I swear to you on my son's life, it was not intentional. What she was talking about was that George passed, was that George died.
So that makes it true because she swore on her
That
son's
was
life.
intentional. She thought he was fine in there. Would he sober up?
I don't think she did it intentionally
We
either,
learn from
right? But that
history.
doesn't mean that it's not criminal. He needs to wrap it up because there's some counts in here, lesser included, that just involve negligence She was absolutely 100% negligent. Maybe we could all agree on that. But she was compost Mentos. Wrap it up. I'll take it. Wrap it up.
When Sarah gets drunk, she calls for help. When George gets drunk, he beats Sarah. That's their pattern. How many times do we see Sarah call the law? That's their pattern. Sarah told him, I didn't know, I think she said, I didn't know something like this could happen. I've never done it before. And Detective Lowen said, well, what did you expect was going to happen? Now, I've got a daughter that she's about 18 or 19.
Don't
she got,
bring your kids
she
into
got
it.
grandmother's hand-me-down pickup truck. It was an older truck, but she didn't have it long, and she was gassing it up, but she didn't put any oil in it. Eventually, it burnt the motor. And you don't know what you don't know. I hadn't done a good job of explaining, hey, you got to put oil in it too. Sarah Boone didn't know that he could die in there. It's an old beat up canvas suitcase that she left a gap in. And as naive as that sounds, she didn't appreciate the danger. I mean, is that the way you want to kill somebody? Is that the way you're going to do it? She had Lucas to take care of. Am I going to go to prison doing it like this? No attempt to hide the crime. I think the evidence is clear. That's how this happened. I don't want to belabor the point. I do want to show you. Just quickly show you. Sarah Boone got stabbed. Don't think about that. Stabbed with a steak knife in the leg. And she stayed with him. She stayed with him.
Actually, her testimony was that he poked her with the knife, and I believe that there was some staph infection or something that caused some surgery, and that's why the wound is so large. But I don't think that length of that wound is indicative of the stabbing or slicing or poking.
Poked between the eyes with a curtain rod. Stalked in the eye. And who does that? The law empowers an individual to defend their life and safety when faced with a threat and to prevent an attack. That's what Sarah Boone did. That's what Sarah Boone did.
That's what I'm saying. Yes. Agreed. Please make it stop.
I think it's important to understand Sarah had to be the parent a lot of times. It was her place. She had that $1,000 a month from the divorce settlement coming in. She had the car. She had the phone. She had the keys. She had to be the parent in a lot of ways.
It's got 15 minutes left according to my watch. I don't think he needs it.
I want to talk a little bit about Dr. Harper. If you remember, Dr. Harper is from Okaloosa County, which is up in the Panhandle, close to where we're from. And she's the
telling me?
doctor that treated Sarah from early on.
You don't have your camera on, Al Lock.
I think she first saw Sarah Boone shortly thereafter. And over the 4.5 years, saw her 9 times and did all the testing for
She's
post-traumatic
been
stress.
testified poke to
She
poke.
has the experience from veterans, and she's testified that she's now just traveling around the state, testifying as a forensic psychologist. But she talked about how important it was to develop trust with the patient over a course of time. It's just going to take time when we have somebody suffering that kind of trauma and that kind of damaged psyche. It's going to take some time to get them where they can trust you and really tell you and talk to you and tell you what's going on with you. She talked about that Sarah uses her words for power. I think her testimony, I think the evidence supports that her testimony was credible.
Objection.
The evidence supports that her testimony was
Objection
credible.
is sustained.
I can't give my personal. Okay. The evidence supports that her testimony was credible because of the time that she spent, because of the number of tests that she did, and she diagnosed her with post-traumatic stress disorder, alcohol use disorder, I think that anxiety disorder, and battered spouse syndrome. Dr. Warner confirmed that. And, Dr. Michael Brannon, the first witness, he was brought in as a subject matter expert. So he hadn't treated Sarah. He was just testifying about the condition. He's been doing it a long time. He's an expert at it. And that's to advise you to try to understand what's going on.
I mean, they have the opportunity to do a rebuttal, but they don't need to. They should just stop. The jury's tired. Let them go
And as
eat.
crazy as it sounds, in this syndrome, they try to protect the abuser. They're in love with them. They try to protect them. I don't know if you remember, but there was a time where Sarah Boone had a conversation with one of the neighbors, and they were talking about something. And she said, "Did you hear anything yet last night?" Remember, she said, "Shh, it's okay." Both George and Sarah lied to the police. They lied to medical people. I don't know if it's training, but it just comes with the syndrome. That you stay trapped in it. I think another big, if you'll think about this. When Sarah gets beaten by George, she calls the police. When Sarah gets beaten by George, she calls the police. And a lot of times she just wants him out. Just get him out. Get him to leave.
This is an interesting comment because apparently you haven't been watching the trial here, have you? Karen is innocent and her voicemails and texts were worse. Ashley was justified with less proof of injuries, empathy for Carly, none of that for Sarah. Why? Because you don't like her personally. I've had empathy for Sarah for this entire trial. I have been roasted for it, quite frankly. So I guess you haven't been watching the trial here at all. But thanks for the comment.
Wants him out. There never was a report of George calling the police on Sarah. She wasn't physically abusing him. The state is trying to present evidence that she emotionally abused him.
Sustained.
Move strike.
Stricken. Members of the jury will pay no attention to that comment. Give it no weight whatsoever.
I believe the evidence that's been presented by the state is an attempt to show that Sarah mentally or emotionally abused George Torres. Again, she's not charged with that. She's not perfect. Some of that was her trauma. In Sarah's situation, you do become numb and hardened, I think, over time. That's a coping mechanism. It's a day-to-day thing, some good days, some, But the homicide detectives, I know if you saw that 2-hour video, at some point during the 2-hour video, they started talking about some of the violence. And they go, we know. They had already checked with neighbors or whoever. They knew. The neighbors knew. Police officers knew who responded. Torres' family knew. They all knew about the abuse. Dr. Harper testified that abused women act differently when they perceive a threat. I think Sarah Boone was loyal to a fault to George, even through all the abuse. Judge, I want to make a comment about a couple of things that were said by the prosecutor in opening statement.
You may proceed.
Okay. The prosecutor in opening statement, when he was talking about George Torres passing away, he started talking about Sarah Boone. And his quote was, because I wrote it down, George, in Sarah Boone's mind, George Torres deserved it. George Torres deserved it. That's the position they're taking. He deserved to die. She loved the man. She wasn't trying to kill him. He also commented about
Judge, may we vote?
Yes.
We've been calling her Seraphim a lot.
the prosecutor said in opening about the violent episodes. It's a bunch of violent nonsense. Was his statement to you, an opening statement. All this here, the photographs, is a bunch of violent nonsense. You'll have to make your mind up whether it's that. There were a couple of exhibits that I introduced late, and they were no contact provisions, where there had been a court order from a judge, not only a verbal order, but it was reduced to writing. So there was a court order for Jorge Torres not to have any contact with Sarah. Okay? Court system got involved. They would have no contact with Jorge Torres. Now, I need to talk a little bit about that. And they talked about coercion, coercive control, power and control, power and control. We know about his abuse. We know he destroyed the home, the TV. We know about his jealousy. You know, some of the things he said to her. We know about how he treated her dogs nicely when he was sober, but at times abused the dogs or threatened to do so. If you think about power and control, when you're controlling a person, and I think she testified that he kind of smothered her, always around her. Part of his fear was her realizing that she had enough and to leave it for good. That she would get the strength over time if she had enough time away from him where she wasn't in control of it and he wasn't in control of it. Enough time away, she would come to her senses and realize she could do better. The judge has been given court orders all week. I didn't stop Jorge Torres. Jorge Torres knew he was going to lose control. If she had a bunch of time away from him, she might move on. He was willing to violate a court order to maintain control. That's Jorge Torres. I want to show a couple of videos, and I want to say something to you.
Thank you, Ray Dean, for the very generous Venmo. I appreciate you. Go Buffs.
Shelby Andrews is going to help me. If we could dim the light.
Yes.
This is like too long. Too long. I know. I thought he was going to tag his partner too. He's not going to be able to. He's going to have no time left. He ate up all the time.
Do you understand? Do you understand? As of this moment, and until I can get you out, get the fuck out of here. You're a rookie. I dare you.
Did you see him?
Yeah, look. Wait, get away from me. Get away from me. Get away from me. I'm gonna scream bloody murder. I'm gonna scream bloody murder.
Did you see him flip the switch? In that instance? Where he lost it? Even though the video was going. Show the next one.
Makes me jump every time.
Thank you, Judge. You turn it off. Can you turn it off?
Oh, there's no bruise on his neck. It's a
Ladies and
tattoo,
gentlemen,
actually.
Finish up right here.
It's a tattoo. It's a tattoo. Somebody looked it up.
Sarah Boone, I've gotten it up.
Objection. Improper argument.
Sustained.
Sarah Boone is like any other citizen. Equal justice under the law. She's to be treated like any other citizen. Fairly and impartial. Based on the circumstances she was facing at the time of this tragedy. Based on the battered spouse instruction, which is a special instruction that's given when women have a heightened sense of fear
Should be wrapping.
and trauma, that you're utilized
It's like
in
done.
applying her subjective standard to the reasonable standard of what a reasonable person would do under her circumstances and using the force that she used to defend herself.
I had to go through some text messages.
I hope I hadn't missed anything. I've tried my best. Sarah Boone fought back and survived.
Right on.
We ask that you do justice in this case and find her not guilty because the doubt is reasonable. I've tried to show you where the doubt was. I trust your judgment. We spent a long time picking the jury, 4 days. We trust you. We appreciate your service and your obligation to do your duty. You have the power and authority to right this wrong. That's what we're asking you to do. And give Sarah Boone some hope for a better life and freedom. Thank you.
Please say
Thank
no
you, sir.
rebuttal. Please.
Any rebuttal?
Yes, sir.
You may
No.
proceed.
Oh, no. I think they were both drunks. I don't think it was intentional. I don't think she meant to kill him. I think they were both drunks. I think they both abused each other. And I think what she did was horrifically negligent and reckless. I don't think it rises to the level of second-degree murder. Shoot me. I think it's down. I think it's one of the lessers. I can't decide which one. I'd have to go back and look at the jury instructions again, like the jury's going to have to do, because like, don't bore that. They've heard it all. They've already made up their minds probably. Like, you don't need to keep doing this. There's nothing more that you could say at this point that's going to make any difference, I don't think. Sheesh. Hi, Mississippi. I mean, it's all you're going to do is make them mad. They're hangry at this point. We're all hangry. Dean, boring and confusing. He needs a ginkgo biloba and a cup of coffee. And with Sarah, one of them would have ended up unalive eventually. Alcohol kills people if they don't kill each other. Oi. Alcohol is evil. Evil. Cyber chick in Boston. Thanks. Melanie Mods and Cupcakes for a safe place to watch this difficult trial.
Ladies and gentlemen.
All of you. Thank you. Heroes.
Jorge Torres is dead because the defendant believed he deserved to be zipped shut in a suitcase so that she could make him feel how she felt when he cheated on her.
It's going to just be repetitive.
When
It's
he choked her.
cumulative. It's cumulative.
And to hold him there as a captive audience, according to her testimony.
They just want last
Now
licks.
he has to listen to me. Well, right out of the gate, there are credibility issues. Cheating to me means viewing pornography. Well, we saw cheating really means women.
That would be good.
And the heated conversation on June 14th about these women in Facebook And that is what leads to the arrest on June 15th. He's out pouring, Candy Crush, all the bizarre things that you see in her phone. He uses the legal system as a weapon at times. There's no denying that they are engaging in violent behavior, and it is over nonsense. It is smashing TVs. They call the police, and then they're standing there looking bewildered about what to do and who to say, and laughing and joking.
Say?
Ladies and gentlemen, the courtroom is the place for justice, not a suitcase. The reason we have a jury system originally started with the idea that the king, the crown in England, shouldn't be able to go and incarcerate citizens on his whim. So it developed into a system where citizens would have to say, yes, you can take our fellow citizen. But the opposite is also true. A citizen cannot take another citizen's life because he or she feels like it. That likewise requires a jury to decide that it was objectively reasonable for a person of ordinary prudence and caution. Like Mr. Cacciatore argued earlier, battered spouse syndrome is not a license to kill. Past grievances, even being stabbed in the leg, so on and so forth, do not give her the license to kill. There are still laws in place about when and how this can be done in a justifiable manner. I want to talk about the most important jury instruction in this case that has not been discussed very well or thoroughly.
Who are you blaming? Whose fault is that? Mediocre chicken cacciatore with Boone's Farm. That's what's for dinner. Thanks, Aaron.
However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself. And we'll stop at that comment. The facts of the case that came from her own mouth, if she is to be believed, and we will explore thoroughly why you should disregard every bit of her testimony, from court to the detectives, to the 911 operator, to the doctors. Her testimony, if it is to be believed, the most favorable light that she has presented of herself, is that at the end of a Sunday fun day, where we're drinking, we're outside by the dartboard, we're doing puzzles, we're doing arts and crafts, and there finally comes a point in time where we're going to play hide and seek. And he says, tag, you're it. Even though she's it, she goes upstairs, hides in the shower, eventually gets tired of being there, it's cold, so on and so forth, and she comes back downstairs. And as she comes back downstairs, she can see Mr. Torres fiddling to place himself inside the suitcase to try and hide for this game.
Make me laugh,
The lid
chat.
is not closed, it's flapping. And out of jest, out of levity, undisputed according to her testimony, she comes over there and zips it shut. Whether it's 100% or enough for 2 fingers to get out, that is something that you decide as the jury. But there came a point in time where the fun and games was over. And Mr. Torres told her that. Babe, I can't breathe. Sarah, babe, let me out. This is all on video. We don't have to imagine this. This is all on video. 1062. At that point in time, she is using force against him that is not justified. She is the initial provocateur.
Provocateur?
She is the aggressor under
I
the
would
law.
not use the word provocateur
And what
and
level
Sarah
of
Boone in
force
the
is
same
it?
sentence. No joke.
I can't breathe. Not let go of my hand, not get your hands off me. I can't breathe. This is no
She
different
should.
than 2
Absolutely.
people, maybe they're buddies at the bar, similar to an example that was given by Mr. Owens, who are wrestling, and one has another one in a headlock. And there comes a point in time where the person on the receiving end of the headlock says, that's enough, I'm tapping. Jorge Torres was tapping, and she ignored it. And she was kind enough to tell you why. Out of anger. which translates to hatred, ill will, spite, just like that in jury instruction for second-degree murder. She told you exactly why. She got angry. Him saying, "I can't breathe, babe," was what triggered her. Not a fear of imminent harm.
A good show.
Those are her own words. That is the law. These are the two paragraphs that solve this equation without getting up on a big whiteboard in college that's 30 feet long, 15 feet high, and a ladder, and somebody's scribbling Latin words.
What college did you go to?
For months and months to solve
college
this
did you go to?
complicated equation.
Okay,
The
apparently
equation is solved in 2 paragraphs. She is the initial aggressor. He is saying, "I can't breathe." It is no different than a naked chokehold that she does not let go of.
I'm sorry, this
And
is
she
not
told
funny,
you it's
but
because
I need
I
to
want
tell
him to
her
listen to
right
me.
now.
This is my bully pulpit. This is how he made me feel in the past. She doesn't describe it as teaching him a lesson, but that's exactly what she says. I want him to feel like I felt in the past. I want to tell him things. Ladies and gentlemen, we can play semantical games, but that is teaching him a lesson. Therefore, we have to look at the other 2 paragraphs. Because right now, plain as day, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself. And what force are we talking about?
it's true.
Well, the threat of force that she tells you she was facing was him fighting for survival. Him sticking his fingers out of the suitcase. Him sticking his hand out. That is the threat of force, coupled with, "I'm going to end you." Well, ladies and gentlemen, she is the initial provocateur. She is the one using deadly force against him. If I have somebody in a rear naked chokehold, they are entitled to use deadly force against me to break that chokehold.
See, the defense could be objecting to all this. Cumulative. They already said that. The first guy with the waistcoat, he said all this in his opening. They don't get to by in his closing. Like he's just, it's repetitive, but he's not.
At least until we're separated. He had every right to say what he said. He had every right to exist and stick his hand out and try and survive to breathe another day. However, the use of force is not justified if you find that Sarah Boone used the force to initially provoke the threatened use of force against herself, unless she does one of 2 things. And she did neither. Not even close.
Bang, bang.
The threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm. All right, let's give her absolutely every benefit of the doubt, which you should. This is a criminal prosecution.
Even your cat is
The
like,
state
"Enough."
of Florida has alleged she committed murder. You need to do everything you can to look for reasonable doubt. But a reasonable doubt is not an imaginary doubt, a forced doubt, speculative doubt. So accepting that all their past history, accepting the doctor's testimony, and the limitations on what they reviewed compared to what we reviewed. We did a much more thorough review of the relationship than any of the doctors did in this case. So let's give her that first clause. Because of their past relationship, with George now fighting for his right to exist and saying that he will end her if he gets out, we'll give her that. But just like Mr. Cacciatore mentioned earlier, lawyers' words mean things to us, and they mean things to everybody, but really to us. Or an and.
Last call for voting on the poll of how long the jury is going to take to reach a verdict.
There's an and. Had exhausted every reasonable means to escape the danger other than using deadly force on Jorge Torres. She did not use every reasonable means to escape the danger that now, after provoking him, that he was presenting to her, according to her. She didn't pick up her cell phone and start walking, call 911. She didn't do anything other than, if you believe that is why she called Brian Boone, made a phone call to Brian Boone, and unfortunately, because of past history, he just ignored her drunken phone call. She did not exhaust every reasonable means to escape this danger that she created. She started it. She created this.
Even the Rage Crochet Club has quit and gone to
Other
bed
than
at this
using the
point.
deadly force on Jorge Torres. Now, this is a weird situation. This is not a rear naked chokehold. This is a suitcase, or as Mr. Cacciatore said, a box.
No, he
Or
called it a
actually,
makeshift
more aptly
coffin.
Described it as a coffin.
He said makeshift coffin. Guys, get your act together and take it on the road.
And when you secure somebody into a box or a coffin, you can still exert that deadly force on them from a distance.
From a
I'll
distance.
give you a quick example from a couple of movies that I love.
Getting punch drunk.
In 1977 in May, a movie came out. It's called Star Wars. They eventually called it Episode 4. In the first scene, there is this large, imposing figure that wears black armor. He is a government agent, and he is looking for some stolen classified documents. He picks a man up who he believes
Star
is
Wars has
responsible for
entered
this
the chat.
treachery, and breaks his neck and chokes him to death when he doesn't tell him where the plans are. We all understand that. That is direct force. We all understand. But what we need to understand is the force she's exerting from the couch. And then when she goes up to bed, she is still exerting that force on him. She set these implementations into motion and did not stop. So later in this movie that came out in 1977,
Yes, please.
another
For
co-employee
the love of the
this
traveling
dark,
Mary,
imposing
let us
figure,
go.
Vader,
We need a
insults
nap.
his religion. He does not go to HR. He takes matters into his own hands
Star Wars?
and chokes
HR?
this person from a distance.
From a distance.
Ironically, while we're talking about force, it's the force. And then in the subsequent movie, he's like doing it from his office. He's killing his incompetent employees on different ships. Force, deadly force, can be exerted from a distance in this situation. So whether she's on the couch or whether she turns in for bed, she is still using that deadly force on him. She has not exhausted every reasonable means to escape this danger. Do something.
You would have lost me
started
with
this.
Star Wars. I'm
You
not
put him
a
in
fan.
position where he cannot breathe. She's required by law to do something about it. Not something, everything. There was no efforts in this case. None. Or, in good faith, Sarah Boone withdrew from physical contact with Jorge Torres and clearly indicated to Jorge Torres that she wanted to withdraw and stop the use of deadly force.
The only thing that would make it better is if he had a
But
Star Wars
George-
tie on.
Just
Look at Tinkerbell.
George
Tinkerbell's
Torres
tinkering.
continued or
Tinkerbell's
resumed
flitting
the
back in.
threatened use of force. That did not happen. She never withdrew from physical contact. She is still like Vader.
Like when anybody starts a sentence with, real quick, you know it's going to be the longest story you ever heard.
Choking him from the couch, choking him from bed. She never withdrew that force. Physical contact includes any restraint on George Torres' movement.
What are we talking?
She never indicated that she wanted to withdraw. Sarah, babe, I can't breathe. All right, if I let you out, are you going to come out peacefully? Since I started this, I'm the one that made you not be able to breathe.
Closing time.
So, ladies and gentlemen, this entire analysis about deadly force starts and ends there. She was the provocateur. These are her
It's a line of
obligations when she
lingerie,
started.
dude.
She put him in fear of death. He is literally telling her, I cannot breathe. A couple other things about the law. Second-degree murder does not require...
Bus driver, please open the door.
Argument was made repeatedly that...
Mommy, my ponytail's too tight.
That has never been the state's suggestion. Because why would we suggest we prove something?
Sir, could you
that we
please
don't have?
move your umbrella? Thank you.
It's not her subjective belief. Well, Sarah Boone doesn't believe that this suitcase...
All together now.
Even though
You
he's
don't have to
repeatedly
go
said, I
home,
can't
but you
breathe.
can't stay
As a person of ordinary judgment who
here.
would know
I know
reasonably certainly kill or consider bodily injury to
want to
another,
take me
a person
home.
of ordinary
I
judgment who
know
hears,
I
I
want to
can't
take me
breathe, babe,
home.
Sarah, and his voice gets weaker 9
They
minutes
get
later.
A pluses for keeping it
You're on
together.
notice. This is statutory notice. Done from ill will. hatred,
Chat, take the
spite,
wheel.
or intent. Her words speak for herself. This was not out of fear. This was out of hatred and anger. Born out of all those horrible things that
Somebody get out
have
the
been
hook.
done to her and done to him. Understand it. We're not going to belabor the past. Is of such nature that the act itself indicates an indifference to human life. I don't care that you're saying you can't breathe. Fuck you.
Hey,
That's
you
my
gotta
name.
you want to
Don't wear it
demonetize
out.
me?
Fuck
You're
you.
gonna pay me $3 that I'm gonna lose
It's
off the ads from this
second-degree
stream,
murder. You do
dude.
not
I'm
have
sending
to
you a
prove the
bill.
intent to kill. We have to. She intended the act. She intended the act of zipping him shut. She continued to intend that act when he said, "I can't breathe." That act resulted in his death. That's a manslaughter, but then when you add in the hatred, ill will, spite, and the depraved mind, that's what makes it second-degree murder. And that 2-minute video is the textbook definition of depraved mind as we define it here in Florida.
It's a good look, right?
Voluntary intoxication is not a defense. You cannot feel sorry for her because they had 2 1.5-liter bottles of wine and then some from the leftovers from the day before. And quite frankly, she's blackout drunk. She's blackout drunk. She doesn't remember making the videos. She turns her phone over right to the deputy the next day because she doesn't know what's on it. She doesn't remember doing it.
Right. And that's how it's not intentional. And that's how it's negligent. Don't give her a better defense now. You should have never started this. Right. She never would have given you the phone if she knew what was on it. So if she had intent and she meant to kill him and she had a depraved heart and all that other stuff that you want to show on second-degree murder, you're going to have to show some kind of cognition of what she was doing. Right? I'm blackout bored. It's not intentional. Oh, for the love of the traveling Mary. No, they're
3
delivering
p.m., 9
tonight
minutes before the video.
till 10.
That portion of her story just doesn't add up. And what it shows is it's more like 20 minutes instead of 11 or 12 minutes
Andy girl.
that we know he's trapped in what turns out to be his coffin. Let's talk about her testimony at trial.
Oh, no, let's
And
not.
we'll talk about all the problems. A lot of her issues predated
They're
her relationship
really
with
like
Mr.
now they're like
So
they're
it's not
clawing their
attributable
eyes
to
out.
trauma from Mr. Torres with all the luggage she brought into the relationship.
Like
And listen to the way she talks. It's
you
not
don't need your
splitting the
15
bills,
minutes
it's
on YouTube.
helping without
okay?
argument. It's not cleaning up and doing Sunday chores. It's cleaning up so
This
you can
is so far.
relax. It's a reward. She talks about him like he's a child. I need to
More
lead
than
him
an
to the next
hour
activity
longer than
from
they
one
had
to
on the
other.
Karen Reed case.
And then you
to
saw the
close,
videos, and I'm not
okay?
going to belabor it, that we showed in rebuttal.
This
but
is an easy case.
the
You didn't
relationship
need to
and the
make it
power
so
dynamics
difficult.
speak for itself. He was treated like the third dog. And it might very well
was
have been
treated
a
like the
dog
third
that bit
dog?
and was
Okay.
violent. But he was treated like a dog.
Wait a second. He may
Why
have
are you
been
leaning
violent.
against my-
He may have been violent. So now you're going to admit that he was violent too? Dude, you had this in the bag. You had it in the bag. Stop the world, please. I want to get off.
He was treated like the third dog. And it might very well have been a dog that bit and was violent. But he was treated like a dog.
Oh,
Why are you leaning against my door? Get out of here. Go downstairs. You're
no.
worthless. You're
Don't go
garbage.
down this road.
They showed the part of the video where he slaps the phone, but that's after 5 or 6 minutes of being berated and dehumanized.
So she deserved it?
In a way that nobody should be
Don't
treated.
do this. Don't do
He
it.
just wanted to get in bed and lay down next to his fiance.
Oh, he just wanted to cuddle with her after he beat the
Instead,
crap out
get
of her?
away from the side of my door, you useless
Why is he doing
dog.
this?
I thought it might be a good point in time to listen to the music. You know, when does Mr. Torres get to decide what to do? I mean,
When he drinks all day, when he gets up and starts
goes off
drinking?
and does all these things on his own.
When he steals her debit card to go
Goes
buy
and
the
buys
wine?
when he's
Sir,
not
sit
supposed to,
down,
does all
sir.
these things when he's not supposed to. But when does he get to do what he wants?
He just threw the whole
Suitcase
case.
downstairs for a
Every
week
day
so
when
they
he
can
drinks
donate
his
it.
face off, every day when he spends her money and takes her car keys and steals her car. You had it. You had it. Why are you screwing this up? Because now every single thing you say, the jury's going, what do you mean, when did he have his time? All he did was drink all day. Luke, I am not your father. Judge, please use the force on this prosecutor and remove him. The music was fractious. That's why. He never got to listen to his music. I'm losing teeth. Wow, you had it. He was a bad dude. She's bad too. They're
What
both
was in their
bad. Together they
lives
were
that was
toxic.
preventing them from getting that suitcase to Goodwill or whatever? Neither one of them worked. What's going on? Lucas is over there on Mondays and Tuesdays.
That's
The story
also a
about
big
the suitcase
mistake.
having already been down there is quite suspect, and we will get into that more. But
No, we
again,
won't get
it's
into it more
not
because
we
you
went
need
on
to
a trip
shut
together.
the
We had a great time.
shut
It's,
the
I
duck
quote,
up
unquote,
and
I
let them
recently
eat.
took him on a trip.
Okay, I'm done. I'm done with him. The fractious music.
We've already gone over. And it's just quite frankly inconsistent because she doesn't, there's no explanation for the picture. Her explanation at trial when I brought it up to her was, I just don't remember. I don't remember this period in time from the picture at 11:03 to when I was supposed to be coming down the stairs. There's a major
You just told
glitch
us she was
in her
blackout
matrix.
drunk. Oh, there's a glitch in the Matrix. Okay, now the Matrix, it's Star Wars. It started with Star Wars, and now there's a glitch in the Matrix. You just said she was blackout drunk. Now there's a glitch in the Matrix? Hold on.
The picture at 11:03 to when I was supposed to be coming down the stairs. There's a major glitch in her matrix.
Oh, in her Matrix, not the Matrix.
She shakes the suitcase. Please stop doing this to me. And then his hand gets out. Now she's the point in time when she gets angry and doesn't do what the law requires after basically choking him with his coffin. Beats him into submission with the bat and turns it back over. For the first time ever at trial, she says, I'm going to fucking end you, is what he said. She never told that to even her doctors. We've heard the arguments why she didn't tell the truth to the police and all that. And there's a lot of truth into the argument that was made. There's a lot of truth. When the argument is made that she didn't understand self-defense, what that means, what it comes across as,
That's better news than this.
she makes the story change as she learns about it. When we apply the jury instructions to her statement, all 6 of them apply against her.
Law students are going to be like, yeah, hit the like while this is going on because this is a money loser. Today's a money loser. Not that I don't love spending all my time with you guys because I do, but I'm going to have a
Since it
herniated
was
disc.
discussed
This chair for so
earlier.
long.
But
I
did
have
the witness have an
whiplash
opportunity
from
to
this whole
see and know
trial.
the things about which the witness testified? Even at trial, she admitted that she was intoxicated for the first time. She went back and forth with the police about whether or not she was intoxicated and her standard of drunkenness and whatnot. But she was so intoxicated that she still felt the effects of it at 1 p.m. the following day.
She was an alcoholic.
The medical examiner told you that alcohol dissipates in the average person. Everybody's different. Tolerance.
We
all those
heard
things
how
come into
drunk
play.
she was.
On average,
We heard it.
0.015.
We've crossed the Rubicon.
Grams per deciliter will dissipate every hour. So you can do the math.
How are these
0.015
guys staying
times
awake, the
14
law students?
puts her at 2.5 times the legal limit. For those reasons alone, you should not believe anything she told you. You should not believe anything she told the police.
We're in hell
You should
right
not
now.
believe anything she told the doctors. She was at 2.5 times the legal limit. She has a gap in her memory that's unexplained when I brought up the photograph at 11:03.
She's a blackout drunk.
You can't have it both ways. I don't remember 11:03 to 11:12, but I was upstairs in the shower hiding. Does the
Well,
witness seem to
no,
have an
because I
accurate
think, I
memory?
don't know, are there any people in the chat who know about blackouts? Like you may remember periods before and periods after, but not the period during the active blackout during which some people can appear to be awake.
Well, this ties into what we're talking about. But
Have more
again,
tie-ins.
there's a glitch in the matrix.
That tie is
11:03 to
terrible, by the
11:12.
way. Speaking of tie-ins,
Her
put that
memory
in the
is not
Goodwill
accurate. By her own
suitcase.
admission, I don't remember. She tells the police
I wish
when they show
were
her the
watching
video,
chat.
I don't remember that happening. Was the witness honest and straightforward in answering the attorney's questions? I submit when we got off script, and by we, I mean with both attorneys.
You're off script now.
She wasn't as honest and straightforward as when it was a very
Yoda,
directed
where's
and
Yoda?
smooth examination. I came out of the gate with something that
Somebody send Joel from
was off
STS
script.
a message, tweet him to
Tell
go
me
pull the
about
fire alarm. Or, Susan
Pamela
Constantine
Erickson. Tell me
was
about
kicked out
Christine.
for
Tell me
her
about
phone. She needs to
she's the one that said cheating to her meant pornography. Well, ladies and gentlemen, she knew exactly who those people were, and that she believed that he was cheating on them with her. And apparently she is too, with some guy named Ben. That when I describe this as a violent, nonsensical relationship, that's exactly what it is. It's not to downplay the violence. She got stabbed. She had minor surgery. It got infected. Those injuries are real.
Oh no, is it?
But they just don't apply in this case. They just don't apply when you use that self-defense instruction when she's the aggressor, if it's to be believed.
Object.
Approach.
Object to his tie. His tie is offending me, Your Honor. His tie. I'm not from here. I'm from a small town. I'm from a small town. Came all this way, and you people are real nice. But I object to his tie. It is offending me and the jury and the jurors. And for as such, that reason, we should let them go to dinner, or they'll try to jailbreak out of here.
Let me say it loud and clear. Battered
Please.
Spouse Syndrome does not have any effect on this case. It has no relationship to this case because she is the aggressor. She zipped him shut in the suitcase after he said, I couldn't breathe, she wouldn't let him out. Therefore, all of the instructions above that paragraph of however do not apply. They do not apply.
I don't know what.
Now,
I
turning
don't know
back to what
what's
I
on
was
that
saying.
tie. That is
Did the witness
ugly.
have some interest in how the case would be decided? Well, of course.
I want a
3 out
Dr.
of 4
Pepper.
panels that y'all came from indicated to the judge fear of punishment was more important than the fear of public speaking. It speaks for itself. She has an interest in the outcome of the case. Now let's talk about, does her testimony agree with the other evidence in the case? You do not have to accept this story. Let's pretend, as you should, because all 6 of these things, we haven't even gotten to the inconsistent statements.
Oh no, you're gonna now go through
Let's
that?
pretend her testimony doesn't exist.
George is getting
You just have to
upset.
look at the circumstances.
George is getting upset. Give me your best Seinfeld reference applicable to this in the chat.
The testimony
Now, a puffy
From the
shirt would be better
defendant.
than what he's wearing right now.
is Jorge Torres' head is here.
I want the timer to
You can
go
stand
off.
if you need. You've been sitting a long time too.
You can stand if you need to.
His butt is kind of down here. His feet are here. And his hands and his knees are up here. He's in the fetal position, if you remember right. The hematoma on his head is on the left side. The bruises, the deep bruises on his back, are on his left side. You hear that? That's solid.
Serenity
You don't
now,
have to
good one.
accept that she put those marks on him while he was in there. The evidence doesn't support it. You can conclude she used this bat when he was outside the suitcase. You don't have to believe her when she said they were playing hide and seek. You don't have to believe her because she doesn't know the rules. She came downstairs,
Oh yeah, she doesn't know the rules.
saw what she had done, and had all the opportunity
Tie
in
is
the
not
world
sponge worthy.
to clean up whatever mess may
You're
have been
right,
at the bottom of the
Bojangles.
stairs. But ladies and gentlemen, physics doesn't lie.
Physics doesn't lie. I'm sorry. Did you watch the Crash Daddies? Physics doesn't lie. The Crash Daddies have entered the Sarah Boone trial. Did anyone ever hear that? Did everybody hear that? Summer of George. Festivus for the rest of us. He talked a lot about airing grievances. Airing grievances. It's Festivus. No, bat for you. Excellent. Physics doesn't lie.
Saw what she had done and had all the opportunity in the world to clean up whatever mess may have been at the bottom of the stairs. But ladies and gentlemen, physics doesn't lie. She can't expect you to believe her testimony about the loud boom being the day before compared to her two neighbors who weren't drinking, who have no interest in the outcome of the case, who suffer from none of the infirmities of her testimony. She suffers from all 6 infirmities. When her neighbors say there was a loud boom that night, there was a loud boom that night. Did it shake the wall they shared in common?
Was there a bang bang?
It shook the
Bang
wall
bang.
that they shared in common.
Bang bang. I want to go watch someone else's
Did she
show.
have any injuries
I don't even know
consistent
who
with
anybody
being dragged up and down the stairs the night before? No. You saw the pictures the CSI took. You don't have to accept her story about hide and seek.
We can't because we're in real time. We can't fast
Energy that
forward
could
through it.
very well be in the form that the girlfriend on the other end.
We got nothing.
Something loud happened. And then there was silence, according to the witnesses. And they can argue that Juan Torres' testimony was great for them.
I'll let him
It's
have
great
it.
for the state.
I'll let him have it.
She was screaming at him already at 7:30 p.m. She was already on her bully pulpit.
Her bully
And we
pulpit.
know she doesn't need to put him into the coffin to get on her bully pulpit. There's video after video of her on her bully pulpit telling him how it's going to be,
Bully pulpit.
how you're going to live your life. Go take a walk. Do this.
Get a job.
Do that.
Stop drinking. She's such a
You
nag.
don't have to accept anything she said. It's inconsistent that he received the hematoma to his head, his bloody mouth. How is his mouth getting bloodied inside the suitcase? That's protected from her.
We're on
her
real
back.
time, unfortunately,
But
yes.
that suitcase,
Jason and I
a
broke the news
100-pound
when it
drunk
first
woman
broke.
is not beating through the wood of that suitcase or whatever it is that's making that noise when it's thumped. Ladies and gentlemen, those injuries happened outside of the suitcase. Ladies and gentlemen, somebody or something went down those stairs. She has no injuries consistent with going down the stairs. He does.
We're stuck in the
He has
Matrix.
blunt force trauma all over.
We're stuck in the Matrix, and we got people on both sides of this case here. We are all in agreement that we are stuck in the Matrix.
The inconsistencies, I'm not going to belabor it. Your dinner is waiting him back.
You've been belaboring it, and now their dinner's cold.
Let's just briefly talk about the experts, and we'll move on.
Anytime
to
anybody
the
says
end.
briefly, like Lally, I'll
Dr.
be brief.
Brandon is absolutely fantastic. He explained everything that you all needed to know about battered spouse syndrome. And this isn't about
Oh, we've been
whether
here all
one of
day.
them or
We
both
are
of
getting
them have
feral.
battered spouse, because at the end of the
You don't
day,
even know.
she's the initial aggressor, and she had to
Started
do
at
what
7:45 a.m.
the law requires. But it does call into question the credibility of the past power dynamics of their relationship. Those videos speak for themselves.
I think we should all get college credit for this.
The
We should all get
officer in the last
$100 in
video asked
Amazon
him,
credit.
Dude, you're a guy. Why don't you do something about this woman, your wifey, who you don't want to rat on for beating you? It's like, man, I'm not a beefcake. I'm not gonna rat her out.
A beefcake? Who's a
There's
beefcake?
countless examples if you apply Dr. Brandon's testimony to Juan Torres
Hi, Brian.
that
from
really
the
shows you
Goodmans.
the power dynamics
I'm
of the
tired.
relationship.
I'm over this already.
He was her violent
Thank
pet. Dr. Harper. I don't find much quarrel with what she says about battered spouse syndrome, and nobody should. I mean, she's the expert. But she's not Ms.
Let it
Boone's
go,
treating physician.
let
She's
it
not her treating
go.
psychologist. The way it was described in argument, and I believe from Dr. Brandon's testimony, was she's supposed to be a forensic detective. Get to the bottom of this. She's going to come in here at trial and tell you her opinion you should rely
Lord,
upon.
I was born around
With 9
the
visits,
man.
she never asked the defendant what it is the victim said that put you in imminent fear
Trying to
of death
make a
or great
living
bodily harm.
and doing best I
That's the
can.
crux of the matter, Doc.
When it's
You're never going to ask her
time
what
to
it
leave
is
it,
he said or did
you'll
for this
understand.
grand jury instruction about threat of force or use of force. It's remarkable. And, you know, she didn't review everything that was presented to you. At the end of the day, it's your opinion that matters about this relationship. And again, we agree with Dr. Werner. It doesn't matter. She had the duty to retreat. She had the duty to
That says a
take
lot.
the chokehold off. And if it was too dangerous for her to directly take the chokehold off, She had the duty to do something else, everything in her power
Is there a
to stop him
chokehold?
from dying because she started it. She set it in motion.
You
She
sound as
used the
whiny as
force
she
grip
does
on
now.
him from a distance. The
She started it. She started it. Yeah, I hope none of those law students have a
She from
date.
bed. It was her obligation to stop, and she didn't. But Dr. Werner, she was called by the state of Florida after having evaluated and listened to the defendant give a similar story and concluded battered spouse doesn't apply. So she was never asked to delve any deeper into it. Given the information that she did have, the limited information, she agrees. Yes, Miss Boone has battered spouse syndrome, but it doesn't apply to the case because she was the aggressor and she did not fulfill her obligations. And really just your gut common sense. Go back to jury selection. In jury selection, there was examples about bullies day after day doing something to somebody. And somebody raised their hand and said, don't they have to do something that day?
And it's
Don't they have to do something that day? And he didn't.
don't know who.
After he was put in fear of death and told her he can't breathe, the imminent threat of great bodily harm and death she is describing to you is him fighting for his life to escape. She did not fulfill her obligations.
You did. And it's just a
There's
box of
details that
rain.
matter. Again,
Ribbon
it's not to
for
belabor
your
it. The
hair.
evidence in the
Such
body
a
worn camera
long
and the
time
911
to
calls,
be gone,
it's not offered to prove
and
the
a
truth of the
short
matter of
time
who
to be
stated
there.
what. Who knows what happened between these two? You see them with the police. Can't believe anything they're saying. It's not offered to prove that she's a bad person. It's not offered to prove that Mr. Torres is a bad person. It's simply offered to call in question the reliability and credibility of what she said about the past. That's all that it's there for. But there are some nuggets and some Easter eggs. There was an argument made during closings that Mr. Torres knows not to do anything when being videotaped.
Freedom's just another word
Bizarrely, shortly
for
thereafter,
nothing left
they
to
showed a very
lose.
edited clip
Nothing. I'm gonna start
of
taking
him
requests.
attacking her and slapping the phone out of her hand. He knows he was being videotaped, and there was another video like it too. So to
Deanna
make
and
the argument
Brian,
that
the
he doesn't
Goodmans
do
are here.
anything, he's a good boy.
Thank
when
you,
he's being
Goodmans, for
videotaped,
being here.
It's belied by their own argument. They showed one of the
You have no
videos.
kids tonight, and you're spending it with us. You
Learned
guys,
helplessness.
you
She
guys
seemed
need
to
to,
control everything. I mean,
this
his birth
is
certificate
too
gets
much.
torn up when he
Thank
doesn't
you,
comply with
Goodmans.
her wishes.
Deanna and Brian.
You'll see the rest of the text messages if you choose to delve into them. But I would suggest you don't have to, given the jury instruction about aggressor.
Country road, take me home.
Ladies and gentlemen,
to the
this has
place
been a long
I
2 weeks, and you are
belong,
making a very,
West
very important decision
Virginia,
for
Mountain
Ms. Boone,
Mama,
and a
take
very,
me
very important
home.
decision for Mr. Torres and the state of Florida and his family. He's dead.
We know.
She killed him. She's admitting she killed him to have this affirmative defense if I was justified. It was not justified under our law. She does not get to decide that she has a license to kill because of her past grievances. The law requires
Airing of the grievances,
her to
Festivus.
stop using the force that she started applying to him.
The force
And she did.
be with you. May the force
She
be
didn't
with you.
Withdraw. She didn't tell him he was withdrawing. She didn't use every means available to try and stop.
The
this
World Series
from
is going to be
happening.
over by the time you're
She
done.
didn't.
The entire,
You know what
all
was in her
7
heart.
games.
She tells you it's hatred, ill will, spite, and venom. This is not a self-defense case under the law. Go back.
Well, we knew that
follow
before you
the
started,
law.
maybe. So, you
You
know.
cannot feel sorry for her. You cannot feel sorry for him. You cannot feel angry at her. You cannot feel angry at him. It's maddening to see their relationship.
You know what's
It is
maddening?
Nobody
This.
would want this life for yourselves or your children.
Yep.
It is violent nonsense.
Yeah.
But it does not affect what she did and what her duties were under the law. That
He
night.
said duty.
She wanted to punish him. She did. And then she left him there.
Must be
And she
getting
had an
early.
obligation. If you
Clocks are
believe
running
her
late.
story about the imminent threat for him fighting for his life, she had an obligation to do something about it and not just go upstairs and let him suffocate. Thank you.
We will get by.
Thank you both.
Do-do-do-do-do.
Members of the jury have some additional instructions.
No, you
to
don't.
read to
Oh,
you.
no, you don't.
If you would be so kind.
Oh,
to
no.
Turn to page 21 of 22.
Yeah, no. I'm out, you guys. I'm out of here. I'm out. If you guys want to watch this, you can go over to Law and Crime. Good luck surviving over there. We are not listening to any more of this. I will watch the TV and see if they come back with a verdict. And if they do, I'll just come on. We're just going to come on. We're just going to do the thing. If it happens tonight. Jerry, thanks for the Canadian 10. I think Owens did a great job of holding Sarah back in her testimony. She was not comfortable. She was pro se. It wouldn't have gone well. I wouldn't want to be a juror on this. I'm for a lesser included, he said. Jerry said, I'm going either way. I'm eating either way. Agrees with me. Thank you, Neen Mock. Thank you, Neen Mock. Jerry, how will our friend Peter Tragos unwrap this later tonight? I don't know. Do you guys even have any more energy to even listen to any more of this? Good luck with that. I will not see you in his chat, and I do love him. No shade at all to Peter. I love him. Amazing the difference with a fair judge. Too bad he couldn't go to Dedham. Melanie, you're the best. Thanks, Husky Lover. Shauna gifted a membership. Thank you so much. Jennifer, thanks for the 5. Says you're awesome. My wife just turned me on to your channel. You're on one of our TVs at all times. Oh my gosh, that's a lot of pressure. That's a lot of pressure. I mean, look at this. This is a mess. This is an absolute mishigas. Thank you. The Goodmans, look, see, there's Mr. Goodman, Brian, threw in a 10, and then Mrs. Goodman. They have no kids tonight, and they're with us. Thank you so very much for hanging in there with us, you guys, and thank you to, whoop, whoop. I got to put the Carly Gregg show up for tomorrow for the grandparents. They're coming on my show with Bridget, Todd at 1 p.m. Eastern. I'm going to be posting it soon. Allison, thank you so much for the Venmo. You are so very kind, but there is nothing that I can do to make those closing arguments stop either. Radine for the very, very generous Venmo. And there's some coffees here. KK bought me 3 matchas. Thank you so much. I'm going to need all of it tonight. And Elizabeth, thank you so much for the Cash App. Thank the mods, you guys. Big round of applause for the mods for getting it done. This was like a more difficult case, I think, to cover than we thought it was going to be. We thought we were going to come into this. We thought there was going to be like a slam dunk. Guilty, easy peasy. There was a lot of divisiveness, which I thought was good because I thought a lot of people were really thinking about it and really thinking about, Sarah may have been abused too, and he was abusive and she was also abusive. And, there could be more to this case than we thought for the past almost 5 years of listening to, her and her crazy rantings and her crazy letters and all those things. They are deliberating until 10 p.m. So if they come back with a verdict and I'm still alive or awake, I'll come back. We'll see it. If you have any questions for Carly Gregg's parents, I don't think I'm brave enough to have the chat on while they're on the show. So I don't think I'm going to put the chat on, but if you would like to submit questions in advance, you can send them to this email, fanbase@mlittlelaw.com. I know that they are very grateful for all of your support. And it means more to them than you know. Those of you that have been sending Carly books in prison and also have been supporting her in general and contributing to the defense fund. They really appreciate it. And I think they want to come on and thank you for that. So it felt like 6 weeks. I can't believe this job was only 6 days. Like, I don't know if I can ever do this again. I think I'm tapping out. But we'll be back. We always say that, right? We always say that. All right, you guys. Thank you for everything. Just do the YouTube-ish type things that YouTube likes. Smash the like, comment, be nice to each other. Tell your friends, share the stream, whatever you feel like doing tonight. I don't want to put the pressure on because we all need to take a nap. So just, be cool, be kind, be classy. It's really not hard. I'll see you back here at 1 p.m. Eastern tomorrow with the grandparents of Carly Gregg. And I think that is, you're going to like to talk to them and show your support. So thank you so much. Peace. Maybe I'll see you tonight. You never know.